Morning, everyone.
Good morning.
I take it that our witness is Dr. Ahmadi.
Yes.
That's correct, yes.
Good afternoon to you in Dubai.
Good afternoon to you, Your Honor.
Are we ready to proceed?
We are, yes.
Well, then I'll just deal with the oath, and then I'll put him in your hands, Ms. Ahmed.
Thank you.
Dr. Ahmadi, witnesses who appear in this court give their evidence on oath. It can be a religious oath or a secular oath. What's your choice as between a religious and secular oath?
No religious. I will give my oath in my Holy Quran.
Thank you very much. Would you like to take the Quran, if you have it there in your hand, and just listen carefully to me and answer my question? Do you swear on the holy book of the Quran that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much.
Thank you, Your Lordship. Mr. Ahmadi, you prepared 2 witness statements for these proceedings. Can I ask you to turn up the first witness statement, please? It's at section 6, page 61.
Yes.
This is the first witness statement you prepared. Can I ask you to confirm your name and address as stated in that witness statement for the court, please?
My name is Muhammad Ghuloom Hussein Ahmadi. My address is in TABARAK Investment Capital in Dubai, DIFC.
Yes, would you like to continue with the address?
The address is TABARAK Investment Capital, Burj Daman, office number 208, Dubai International Financial Center, United Arab Emirates.
Thank you. And if you could go to the last page of the witness statement, please. That's at section 6, page 86.
Yes.
You see at the bottom there a signature. Is that your signature?
Yes, it is.
And therefore, do you confirm that the contents of this statement are true to the best of your knowledge and belief?
I do confirm, yes.
I beg your pardon?
I confirm, yes.
The second witness statement you prepared in these proceedings was a reply witness statement, a responsive witness statement. If you could turn that up, please. That's section 7, page 31.
Yes.
I'm going to ask you to turn to the last page of that witness statement, which is at section 7, page 49.
Yes, I'm here.
Do you confirm that's your signature?
Yes, I confirm this is my signature.
And therefore, do you confirm that the facts stated in this witness statement are true to the best of your knowledge and belief?
Yes, I do confirm.
Your Lordship, may I seek permission to ask some supplemental questions based on the new witness statements that provided by Mr. Saxena and Mr. Al-Ali?
Yes, certainly.
Grateful.
First of all, can I ask everybody can hear me clearly?
Yes, I think we can. I can certainly hear you, and I think everyone else can. Thank you very much.
Thank you.
Thank you. Mr. Ahmadi, there were 2 witness statements that were served a day before the hearing. Those were on behalf of Mr. Al-Ali and Mr. Saxena. Can I ask you first to turn up Mr. Al-Ali's witness statement, which is at 27-38.
Yes, I'm here.
And Mr. Saxena's witness statement, just for the record, is at 27-52.
Okay.
At paragraph 10 of Mr. Al-Ali's witness statement at 27-40,
Yes.
Mr. Al-Ali talks about the meeting on the 16th of December. In his oral evidence, Mr. Al-Ali also said that he met you on the 16th of December. Is that correct?
No, it's not correct. I've never met Mr. Al-Ali before the incident on 3rd of February.
When was the first time you met Mr. Al-Ali?
On 3rd of February.
If I can ask you then to turn to paragraph 30 of Mr. Al-Ali's new witness statement.
2730, you mean?
27-43, paragraph 30.
Yes, I'm here.
Mr. Al-Ali says in that witness statement, on the morning of the 3rd of February, before the transaction took place, Mr. Saxena and I spoke to Mr. Ahmadi and Mr. Turner. Whilst Mr. Ahmadi initially raised a further protest about the fact that the account opening fee had not yet paid, Mr. Saxena explained to him that Mr. Turner had agreed that it could be deducted from the proceeds of the sale. Mr. Ahmadi didn't say anything about this and certainly did not object and left shortly after to allow us to get on with the transaction. I next saw Mr. Ahmadi again when Mr. Turner gave him the wallet to put in his safe, once we had transferred the Bitcoin to the wallet. Now, pausing there a second, because this covers the same area, Mr. Saxena's witness statement at 27-58,
Yeah.
paragraph 29 says as follows. I mentioned that Mr. Ahmadi attended the first part of the meeting. He stayed around 10 to 15 minutes before leaving. When we arrived, either Mr. Al-Ali or I said something to the effect that we were pleased that HUOBI was a client of TABARAK. Mr. Ahmadi replied that HUOBI was not a client of TABARAK because he had not paid the account opening fee. We explained to Mr. Ahmadi that the account opening fee would be paid today from the sale proceeds, which had been discussed with and agreed by Mr. Turner a few days before. So pausing there a second, Mr. Ahmadi, did you meet with Mr. Saxena and Mr. Al-Ali on the 3rd of February?
I did meet them, yes, on the 3rd of February.
And how long did you meet them for? Was it 10 to 15 minutes, as Mr. Saxena says?
It's incorrect. I only met them a few minutes, even less than 5 minutes only. And when I went to the office, to the meeting room, there were not only Mr. Saxena and Mr. Al-Ali. There were also the buyer was there, Mr. Yabdini as well. So having heard that Mr. Saxena saying that I have agreed to deduct the account opening fees from the transaction is absolutely incorrect. Is it impolite for me to say that, to say to Mr. Al-Ali that you're not going to do, I will not, the account opening agreement will be deducted after you conduct the transaction in the front of other people? Definitely not. It's impolite to say that.
So what do you say happened when you met with them?
I just went there. I just said good morning to everybody, like the presentaries, and say good morning and everybody. I just said even I can precisely say not less than 3 minutes, and then introduce everybody. And I said, okay, I wish him all the best. And that's it. I went back to my office.
And Mr. Al-Ali said he gave evidence that apparently you put your hand on Mr. Morozov's shoulder and explained and confirmed that he was a client. Did that happen?
You mean in the meeting room?
Yes.
No, never happened.
Could I ask a question at this stage, if I may?
Yes.
Do you accept that Mr. Saxena did say to you that HUOBI MENA would deduct the non-refundable fee from what would otherwise be the process of the transaction that was due to your company?
No, Your Honor, I don't accept that. It's incorrect.
Can you help me therefore with the evidence you gave a minute or so ago when you were talking about it would be bad manners and so on for this matter to be aired? What were you referring to then?
Yes, Your Honor. Had they I mean, even if I had a plan to say to Mr. Saxena or Mr. Al-Ali, you didn't pay the account opening fee, I wouldn't say it in the meeting room in front of other people as well. I would have taken them privately aside. I said, listen, you still didn't pay your account opening fee. But this never happened. I never mentioned that. We never discussed about it.
I see. Thank you very much.
You're welcome, sir.
And Mr. Al-Ali gave evidence that he knew you generally, even before the 3rd of February meeting. What do you say about that?
I can only say that is incorrect as well. Mrs. Ahmed, you know that we, in our culture here, if we knew each other, if Mr. Al-Ali knew me or I know him, you think we would not communicate with each other prior to the meeting, prior to any meeting, or prior even to the initial discussion of the transaction? Of course, in our tradition, we talk to each other. We are like brothers if we know. I never met Mr. Al-Ali, or even that don't have his contact details. Neither he had my contact details. I'm glad to hear this statement, to be honest with you.
So when was the first time you met with Mr. Al-Ali then?
Well, he's told us that. He said it was on the 3rd of February.
3rd of February, same day, yes.
And at the end of Mr. Al-Ali's evidence, he said that there were criminal proceedings against Tabarak. What do you say about that?
There was no criminal proceeding against Tabarak. The only thing was there, let me clear to the Honorable Judge and the audience, there was a criminal case from Mr. Al-Ali against Mr. Christian Ternam and Yevgeny Morozov, who was the Russian guy. And then later on, I found out that there is a civil case being raised to us, to Tabarak, by Mr. Al-Ali in front of Dubai courts, claiming that he would like to freeze the assets of Tabarak and everything. However, we defended our case. He lost, he appealed, he lost again. So this is about that. We never had any criminal case against Tabarak. It was civil case only, which we won it in the front of Dubai courts.
Thank you. Your Lordship, I'm grateful. I have no questions, supplemental questions. Mr. Ahmadi, if you'd like to stay there, Ms. Stewart will now ask you questions in cross-examination. Thank you.
Dr. Ahmadi, so you started your working life at Gulf Air, I understand.
Yes.
And then you transitioned into private banking, and you worked for a number of private banks, yes?
Yes, I did.
And you were based in the Middle East throughout. You've been based in the Middle East throughout your private banking career.
Yes.
Dr. Ahmadi, could you speak up a little, please, or move the microphone a little closer to you? We just hear you, but it would be nice if we could hear you more clearly.
No problem, Your Honor. Fine, absolutely. Now, is it clear?
That's good. That's good. Thank you.
And then the company that's now known as TABARAK Investment Capital Limited, that was officially launched in 2014, and you're the CEO.
Yes, I am the CEO, yes.
And TABARAK Investment Capital Limited trades as TABARAK Investment Bank, yes?
Used to be, is not trading. We used to know as TABARAK Investment. In fact, let me clarify. Do you mind if I clarify about this TABARAK Investment Capital? Is it okay?
You said it was known as TABARAK Investment Bank. That's sufficient. Thank you.
It was the previous known was TABARAK Investment Bank. Then we renamed it to TABARAK Investment Capital Limited.
So now, digital assets. Would you agree that crypto assets are a type of digital asset?
I don't agree that digital assets, from my perspective, can I answer you, or you want just?
Yes, of course. Just answer the question.
My perspective or my understanding of digital assets is everything you do is digital. For instance, You want to document is digital. If you want to scan it and comes to your download it in the computer, is digital assets. Audio is digital. Brochures is digital. If you put it in the computer, if you scan it and put it in the download in your PC, cryptocurrency is not a digital assets, from my understanding.
Dr. Ahmadi, digital assets essentially, are they not electronic files of data that can be owned and transferred by individuals, and therefore they can be used as a currency for transactions?
I'm not aware that about the currency or cryptocurrency could be considered as digital assets.
Well, we say that cryptocurrencies are a type of digital asset, and you know that full well, Dr. Ahmadi.
I don't. From understanding, I explained to you what is digital asset from my own perspective.
And a Bitcoin is a type of crypto asset. Do you agree with that?
Bitcoin is a type of cryptocurrency.
And then moving up a level of complexity from straight cryptocurrencies, like Bitcoin, for example, would be, for example, a Bitcoin backed by an asset, like gold.
I didn't understand. Can you please repeat your question more so I can?
You don't understand what I mean, right?
You can repeat the question. Is not understand. Can you repeat it more clearly, please? Mind?
So we have straight cryptocurrencies like Bitcoin, and then we have slightly more elaborate financial instruments, which might be, for example, Bitcoin, that is backed, that's linked to an underlying asset, like gold.
Yeah, that could be considered a solid product if it is underlined or backed by a solid asset.
And Dr. Ahmadi, TABARAK, it would be fair to say, has been well ahead of the curve in the field of digital assets, hasn't it?
No, I can agree with that.
Can I take you to 8-1?
8-1. Yep, I'm in 8-1.
So this is an article in the Khalij Times in May 2017. And the title, 1 gram launched the first ever digital currency backed by gold in an initial offering. And then if we go to the next page, 8-2. We can see 1, 2, 3, 4, 5th paragraph down. TABARAK Investment Bank, one of the largest in Dubai, will sell 100 million to its clients, while a similar amount is expected to be taken up by 7 high net worth individuals. Right? And then if we go to 8-33,
yeah,
we have an article, which is a press release, and it's a release on this 1 gram product. And it says there at the top, at the beginning of the press release, so that's just below the date, the 11th of May, about halfway down. 1 gram today announced an agreement with TABARAK. TABARAK has this opportunity to market/refer a euro million allotment to their extensive group of clients in the Islamic financial sector. Yes?
what's mentioned here is.
So it'd be fair to say, I mean, this was 2017, some time ago, over 4 years ago. Be fair to say that TABARAK, and it's to be commended, was really at the forefront of crypto assets and in developing innovative products?
No, I don't agree. And besides, 1 gram is a bogus company, first of all. They approached the office on May 2017. They wanted to have a meeting with one of my junior staff. And they came to the office, and after 10 minutes, they left the office. Then the staff came and approached me and discussed with me. They said, what happened? He said, these people, they are bogus. They don't know what they are doing. They just come, they wanted to market their cryptocurrency through TABARAK. We completely refused that. We did our due diligence after they left the office. We found out that this is a bogus company. This is not registered in UAE. And that they misused our name for their own benefit, which we were shocked and saddened by reading this articles in a few medias. But at the end of the day, we found out 1 gram, they did this to different other companies as well. So 1 gram is a bogus company, or it's a fake, doesn't have any representation in Dubai. They just came and misused our name. We didn't have any agreement. We didn't even discuss with them anything. We were shocked as anybody else to read this.
Thank you, Dr. Ahmadi. Did you ever write to the Khalij Times to actually to correct any of this?
No, we did not write, because first of all, we would have gone after them and sued them. But unfortunately, they were not present in the UAE. We don't know where they're present. They are, like we found out, they are bogus. Even we did a few research, myself and the compliance department. We found out some picture of the people. They had numbers, but all the numbers were not working.
But you didn't take steps to correct any of this information that had been in the media?
There was nothing that we can do on that. I mean, people, they come and misuse your name and write something is incorrect. It happens every week. So we have not, because they don't have any presence in UAE to go after them.
Right. Can I? Well, of course, you could have gone to the Khalij Times. But anyway, moving on. If I can take you to 8-7.
Yes.
So this is dated 2017, and it relates to what's called the Nacreus coin, and this was
2018.
Sorry, I said sorry, didn't I? Okay, and this is a so-called white paper about the Nacreus coin. And then if we go to 8-12.
Yes, I'm here.
We can see that this is described, the Nacreus coin that is, as a blockchain-based cryptocurrency that's linked to physically deposited gold in the form of a certificate of deposit called the Gold Reserve Sukuk. Yes?
Yes.
And reading through this, what we'll coin the white paper, it'd be fair to say that TABARAK's name is all over the paper, isn't it? There are many questions about the involvement of TABARAK in this Nacreus coin.
TABARAK as an investment firm, management investment firm, we are always willing to look on any opportunities can fall within the scope of our businesses. When Nacreus coin approached us, they knew we have gold reserve sukuk backed by real gold, physical gold. They came and discussed. We've never had any physical meeting with Nacreus coin. We never. It was all over communication by email. It's been introduced to a lawyer, a friend of mine from Germany. So there was a proposal that they wanted to issue this Nacreus coin backed by our gold reserve sukuk. As you counsel mentioned, that if it is any solid asset backed by anything, could be looked into. We always have there is always space to look into any opportunity we have. We said, okay, let's have further discussion. The idea was each coin of Nucleus coin will be backed by gold reserve Sukuk, which is a regulated Sukuk fund. We are co-founder and it's approved by DIFC and it's also in DIFC Nasdaq and everything. Having said that, does not mean that we went into agreement with them. The same scenario happened with them with 1 gram. They went and established this white paper and put it on their website without our consent at all, without even coming to us, showing us a draft of the white paper.
Yes, I've got your position on that, Dr. Ahmadi, thank you. Now, if we go to 8:30.
Yeah.
And on this and the next page is a disclaimer.
You're talking about page 830, right?
Yes.
Yeah.
And what we can see reading through this disclaimer is that it's plainly inserted for Tabarak's benefit. It's to protect Tabarak from liability for any perhaps errors and so on in the white paper. Would you like to look over that and see whether you agree with me?
I did not go through the disclaimer, to be honest with you.
But you agree that this is inserted for Tabarak's benefit?
I did not. I need to read the whole disclaimer and give you my answer.
Would you like to cast your eye? Okay, let me take you to a few paragraphs. End of paragraph 1. Any participant providing false information about their citizenship, residency, place and nationality will breach Nucleus coin terms and conditions and would entitle Tabarak Investment Capital Limited, Bank, not to compensate any damages and or losses suffered due to this violation. Would you agree that that is for Tabarak's benefit?
If you say so, yes, it is then.
Let's go down to the 3rd paragraph.
Yeah.
Tabarak Investment Capital Limited, Bank, and or its affiliates will not be liable to any person or entity for any damages, losses, liabilities, costs and or expenses of any kind, whether direct or indirect, consequential, compensatory, incidental, actual, exemplary, punitive or special, for the use of, reference to or reliance on this white paper or any of the content contained herein, including without limitation any loss of business revenues, profits, data, use, goodwill or other intangible losses. And then let's go to the next page, 8:30. Sorry, would you agree that that's for Tabarak's benefit?
I don't know. I can't say anything because at the end of the day, that was nothing came into all this with our consent. It's all been issued without our approval or even consent.
And if we go to 8:31,
yes,
end of the 2nd paragraph. An Nucleus coin does not grant any right to participate in, control over Tabarak's management or decision-making process or over the Nucleus coin and governance to the purchasers. So would you agree that that clause is also for the benefit of Tabarak?
Would be at the end of the day, as I said, that has not been agreed by us at all. They can mention anything in the benefit of Tabarak or not benefit. That is, as soon as we saw it, we terminated everything, the or the verbal conversation we had with the party with the Nucleus coin. So all this will be irrelevant to us because we terminated everything as soon as we saw the white paper established without the consent of Tabarak. So whatever is mentioned, that really is not.
Dr. Ahmadi, it's simply not credible that you were not involved in the drafting of this paper when there are disclaimers that are plainly inserted for your benefit?
I can assure you we were not involved. I was not involved. I was involved in discussion with the initial discussion with that idea, but I was not involved on creating this white paper at all.
And then we come to Mr. Thurner. Now, also in 2018, Pecunio Blockchain Technologies FZE signed a letter of intent regarding the purchase of 20% of the shares in TABARAK. And we can see that at 8-689.
Yes, I'm on this page now.
Now, Pecunio is a platform, is it not, for blockchain investments?
Pecunio is a blockchain company, yes, it's a blockchain.
Now, that share purchase never came to fruition. It never happened.
No, it never happened.
But we can see, sorry, I should go back to the next page, which is 690.
Yeah.
See that the individual involved in Pecunio there, and the signature we can see is Christian Thurner, as well as another individual, yes?
Yes.
And in February 2019, TABARAK employed Mr. Thurner, correct?
Yes, it's correct.
Now, you had seen by that stage from his involvement in Pecunio blockchain technologies that he had expertise in digital assets, hadn't you?
No, I don't think so. This is true. I don't even think that Mr. Turner has any expertise in digital assets or even cryptocurrency.
So, Mr. Thurner, here in the letter of intent, is listed as the COO of Pecunio Blockchain Technologies. And you're saying COO, and you're saying he has no expertise in blockchain technologies. Is that correct?
Ms. Counsel, I said a blockchain. I said blockchain. Blockchain is a technology. Cryptocurrency is a coin. So the blockchain provides data and system for cryptocurrency. Pecunio is not a cryptocurrency company. It's a blockchain. Blockchain is a technology company.
Well, we'll get to that. But the bottom line is, you'd seen from his involvement in Pecunio that he had this expertise, so you thought he'd be a good hire to develop this side of TABARAK's business.
No.
An area of business that you were plainly already interested in.
No. We talk about cryptocurrency like any other people talk about it in normal conversation every day. It doesn't mean that we are interested. We are not even allowed to even have a cryptocurrency, within our company. We are not licensed for that.
Yes, well, we'll get to that. Right, could you go to 852?
Yes, I'm 852.
So this is an article so it's titled TABARAK Investment Bank and Pecunio Blockchain Technologies Team Up to Cater Selected Digital Assets to the region's ultra-rich clientele. And it's dated the 6th of May 2019. So soon after Mr. Thurner became an employee of Tabarak, correct?
Yeah, that's correct.
And then we have, it starts the article by saying that Pecunio has entered into a collaboration agreement with the prestigious and innovative Tabarak Investment Bank to cater selected digital assets. Now, if we go to the next page, 853, and towards the penultimate paragraph, Pecunio CEO Reinhard Berger comments, Tabarak Investment Bank is one of the few major financial institutions to recognize the disruptive power of blockchain technology, which is consistent with what I've been saying, that, and it's to be commended, that Tabarak was ahead of the curve in this field of activity, was it not?
Still, I don't agree with what you say, Council.
And then moving down a bit, so to the last two lines of this page, Tabarak's MOB and Head of Digital and Asset Management, Christian Thurner, concludes, Tabarak Investment Bank and its banking partners serve ultra-high net worth individuals in the GCC region, and he goes on, says one of the most recurring topics of the ultra wealthy is, simply spoken, how to enter the digital asset market to capitalize on the fantastic growth potential. And that's absolutely correct, isn't it? That lots of your clients, or certainly some of your clients, I should say, are interested in investing in, and have been for some time, interested in investing in digital assets.
That's not correct, Council.
Dr. Ahmadi, could you speak up again, please? I'm very sorry.
Because of
We're
the
not
file,
hearing you very well.
the file was in front of the mic. So
That's better,
no,
yeah.
not correct, Council. Secondly, this media release or the information release on the Pecunio website, I never knew about it as well. I didn't even been told that there will be there is a release saying all this. Had I knew that they're going to publish that, I would definitely going to consent about it, because it's not true. What Mr. Reinhard Berger and one Mr. Christian Turner said about it, this is their own personal representation without referring to Tabarak. They mentioned that without even going back to Tabarak. This is where the Pecunio deal with Tabarak failed. Similar to the other proposals as well.
So, Dr. Ahmadi, you just said, had you known about it, you definitely wouldn't consented, correct?
I would not agree.
Okay. If I could just take you.
And another point here, Council, if I may ask.
If you could just hold on one moment. You say, if we take you to 668. 668. So that's the file with the witness statements, and in particular your first witness statement.
Yes, I'm here.
Paragraph 31, and this is about this. and this is about this particular article, you say, had I been asked back then for permission to publish the press release, it's entirely possible that I may have consented to the publication, but with certain modifications. So that's different to the evidence you just gave, which is that you definitely wouldn't have consented, isn't it?
Let me explain that. I guess to that.
Yes or no?
No, I want to say something to the court that English is not my first language. I might not understand your question very well. I will ask you to repeat it, okay? Secondly, now you can say your question. Tell me what exactly you want to hear.
Well, what Ms. Stewart is drawing your attention to is this: what you say in paragraph 30 and 31 of your witness statement. She
Yes.
contrasts that with what you said in your evidence just a minute or so previously, where you said that had you known about this document, you would not have agreed to it. And she's inviting your response to the contrast between what you've said in those paragraphs and what you said in your oral evidence, that you would certainly not have agreed to it. Now, feel free to respond, and I'm listening, we're all listening very carefully.
Yes, I understand, Your Honor, I understand. So the press release that you showed me previously, that was mentioned on Piconio website, as I told you, I will never agree that. I would, yes, I say I would have agreed in any press release that goes as per the agreement that we had with Piconio. The agreement we had with Piconio is to purchase shares within TABARAK and to establish a physical gold desk within TABARAK, which we are allowed to do. The gold trading desk in TABARAK. So even had they came to me with this press release, they told me, okay, Dr. Ahmadi, this is what we are going to publish, I would definitely consent about it. I would refuse. I would say, okay, unless if you want to do it, this is a modification. This is the amendment, you should put it. So that is my answer to your question.
Thank you.
Now, so you say essentially that Mr. Thurner, when he was employed by you, he wasn't authorized to write this press release. We get that. I'm just going to take you to some printouts from Pecunio's website. And these printouts, first of all, 8702. So right at the end of the bundle with all the evidence.
Yes.
Now, these are printouts from Pecunio's website as at Monday last week, and there haven't been any changes to date. Now, so what we have at 8702 is that Pecunio provides a diversified portfolio of future-proof investment services for professionals, including Pecunio Cryptocurrency Fund and the world's first fully gold-backed digital asset. Yes?
Thank you.
Then if we go to 703, next page, Pecunio is described as offering multi-currency wallets. Now, if we go to 708, there appear to be 9 employees or members of staff of some description.
I can see that.
And yes, and then the next page are listed 4 advisors, including Mr. Thurner. Yep.
Yes, I can see that.
So you'd agree this appears to be a legitimate company?
I did not say Peconio is not a legitimate company. It is a legitimate company because it's registered in UAE.
Now, let's go to 706.
Yes.
So this is a timeline, and we can see at the bottom right, 0418, so April 18, launch of Peconio gold coin. Yes?
Yes.
So when we click on that, click on the more info, let's go to 710.
Yes.
And we can see at the top, it says Peconio gold coin, and then under that, small writing, but it says issued and handled by TABARAK Investment Bank.
Yeah, I can see that.
Yes. And if we go to 704, we can see that TABARAK is listed as a partner of Peconio, correct?
I can see the product logo there.
So Peconio appears to be a legitimate enterprise with quite a few employees, advisors, and Peconio says that TABARAK is and was its partner for the very same product that you say TABARAK wasn't involved in.
This is what Peconio is saying.
Well, Peconio clearly believes that TABARAK was and is a partner.
We never had an agreement with them to have. Which agreement there is that we are partners? As I said, we signed a share purchase agreement only with Peconio, and it did not materialize, and that's it, finished. We got nothing. What then Peconio added on their website, I was not aware of, to be honest with you. And they should have removed the TABARAK.
But TABARAK has taken no steps whatsoever to ensure that Peconio ceases to market its partnership with TABARAK, has it?
Yeah, but we never checked Peconio's website. We never checked it. As you said, this is only this website. What you check is late, is new, is not very old. So, in theory, when you don't have any agreement with any, they shouldn't be putting your name as what it was previously agreed. They should remove it themselves without me asking. I'm surprised, to be honest with you, to see that still TABARAK's name is there.
So you are expecting us to accept that even though you have written about the involvement or the alleged involvement between TABARAK and Peconio, you've written about this in your witness statement. We are supposed to believe that you didn't check the website, that your lawyers didn't check the website.
No, obviously I didn't check the website because there was nothing between us.
Right. Dr. Ahmadi, it's simply not credible that the press release, the Peconio press release that I first took you to, was some kind of unauthorized frolic by Mr. Thurner, was it?
Yes, they are not authorized by us.
And it was entirely in line with Tabarak's business aspirations, wasn't it?
No, it wasn't.
Now, Tabarak has not provided a single written internal Tabarak document stating that Tabarak had a policy of not engaging in crypto-related activities, has it? Not a single piece of.
We don't have to, counsel. We are a regulated license. We know what we are entitled, what we are not entitled to. So we don't need to mention that we are not a cryptocurrency company, because everybody knows we are not a cryptocurrency trading or whatever it is. No.
Well, actually, there's no regulatory barrier to engaging, or there was no regulatory barrier at the relevant time to engaging in crypto-related activities. And that's because crypto-related activities were not, in fact, regulated by the DFSA at the time, were they?
Until now, it's not regulated.
Exactly. In other words, they fell outside the regulatory perimeter of the DFSA, didn't they?
You mean what? All this product that you're mentioning?
Yeah.
Yeah, but we never had. We see, even if we go in an agreement with any product, for instance, Piconio or Neocross, we discuss. As I said, we are an asset management investment company. We always look. We always see if there's any opportunities. But however, we will not do anything beside what we are allowed to, what we are entitled to. At the end of the day, when we see a package is there, we need to take approval of the regulator when we are happy with the proposal with the other party. None of this happened with Piconio or Neocross or any other parties.
Now, you acknowledge in your second witness statement that Mr. Thurner was a senior member of staff at Tabarak, yes?
Yes.
And you also acknowledge that Mr. Thurner's Tabarak email signature was as Tabarak's Director of Investment, yes?
Yeah, Director of Investment, there are two translations. There is one in Arabic, one in English. All the previous Director of Investment of Tabarak before Christian, they always hold the same title.
Yes.
It's not been created just for Christian Turner. No, it was there previously for other employees as well. And
in Mr. Thurner's email signature, we heard from Mr. Al-Ali that the Arabic word mudir, manager, means member of the board, yes?
No, it's not true. Manager, mudir means manager, like you are any manager. Member of the board has different word for it. Member of the board.
Now,
in Arabic is similar as director in English. As I said, counsel, all the previous director of investments, whether they've been senior or junior, they all carry the director of investment title in English, an Arabic manager.
The bottom line is that you allowed Mr. Thurner to hold himself out to the work. You allowed Mr. Thurner to present himself as a senior member of your team. You knew that the term Director of Investments and Mudir sounds like a senior role.
As I said, he's a senior member of Tabarak. He was a senior member of Tabarak. It doesn't mean he has full authority like the board members. No, he has certain job description that he's following as per his contractual agreement with employment agreement.
But a third party, for example, like...
He knows his limit. He knows what he's entitled to talk about. He knows what he's entitled to do. He knows everything.
A third party like HUOBI dealing with Mr. Thurner would reasonably assume that he had a significant responsibility at TABARAK, wouldn't they?
Really, see, he's a senior director of investment, can be relation manager, can be sales, can be marketing. If he has a prospect client or proposal for client, he will follow what we usually do on this term. If we want to, somebody's talking to TABARAK, they want to become a client of TABARAK, I assume he will speak to him, of course, what we can provide, what we can do. He can talk without referring to anybody. At the end of the day, this is part of his job to do.
Yes.
Even junior staff can talk about it.
Well, unless told to the contrary, given his third party, knowing what his titles were, would understand that he had authority to bring in work, to negotiate terms, and to execute new business.
See, he has the authority to negotiate, he has authority to discuss, but he doesn't have authority to execute. The authority of execution is in my authority. However, if the other party was not convinced about the position or title of Christian Turner, or they want a clarification what Christian Turner is entitled to do, they would have called one of higher than the boss of Christian Turner. In this case, will be me. They would have called me, said, Dr. Ahmadi, is Christian Turner allowed to do this? Is he allowed to do that? We would have given them the right answer.
Now, you just said that that Mr. Thurner wasn't entitled to execute business, yes?
Yes.
Right. Can I take you to 841?
Yes, I am here.
Now, if we go to the bottom of that page, duties of the employee.
Yeah.
Now, in his capacity as senior manager, Mr. Thurner's scope of work is very widely defined. And it includes, but is not limited to, that's the wording used in the contract. And if we go to the next page, for example, and as you've said, I understand, 2.2, identifying business opportunities. 2.4, maintaining relationships with clients. 2.5, identifying product improvements or new products by remaining current on industry trends, market activities, and competitors. 2.10, searching for new clients. And further, if we go further down in the list on 2.10, investment operations and handling, advising and guidance of clients. And then we have at the bottom, executing and operation. So do you accept now that part of Mr. Thurner's job description was indeed execution?
How you define execution and operation on this employment contract, but our definition of executing an operation is meant to finalize a negotiation with the other party, discuss about terms, conditions, and everything. But final execution, it has to come to the person who has the authority, which is me.
Now, you knew that TABARAK knew that Mr. Thurner's background was in blockchain and crypto, yes?
No.
You knew this from...
I knew he has a brief idea about crypto like myself, like everybody else.
And you knew from Mr. Thurner's involvement with Pecunio that it was likely that Mr. Thurner would be interested in developing crypto-related work.
Where, you mean within Tabarak?
Yes.
No, of course not. That's not part of his duties or even job. Mr. Thurner knew very well Tabarak does not deal with cryptocurrency. Neither we are authorized, neither we are even permitted to do that. As I said, if any opportunities come, people they talk about cryptocurrency. I have a proposal. You listen, like any other. We are a commercial entity. We listen to any proposal comes. In case something will come within our frame of work of license, yes, maybe we'll look into it.
So it would. So given that you knew that what his background was, it would have been very easy to actually put in this employment contract, no crypto related business.
Council, this contract is standard for all director of investment held this position. There was no need for us to put no cryptocurrency because we know that we are not cryptocurrency. We cannot deal with that. So we cannot just go and adjust any job description because of certain individual if we know that he has a cryptocurrency knowledge or not. When we hire any employee, especially senior staff, it's just we don't hire them just overnight. We discuss, we tell them their duties, we tell them we stress a lot in our activities what we are permitted to do. We cannot. I established this firm and I spent all my money. I'm a chief executive and founder of Tabarak. I don't want to jeopardize my company that I have for something that we are not allowed to do.
But at the time there was no regulatory barrier to being involved in crypto assets, was there?
We are not allowed to do any cryptocurrency trading or assets. Full stop. There was no like before it's permitted or not, now it's not permitted. No. I don't know what exactly you mean, but I hope I answered your question. But as far as I understand, this is what you wanted to ask.
Right. So let's.
As a CEO of the company, I know what is our limitation. I know what we can do. I know what we cannot do.
So if we go to 8447.
8447. Yes, I am here.
So this is a printout from Tabarak's website at the time of the events that's subject to these proceedings.
Yes.
So we can see there Ms. Fouladi, who gave a statement, a document in relation to documents in these proceedings. We can see Mr. Abdul Qadir Khan, who was at the time the finance director, Mr. Malik, who we're going to hear from later. And then we have also as a member of the management team, Mr. Thurner, yes?
Yes.
Now going to Mr. Khan, as I said, at the time he was the finance director, and then if we skip on to page 597,
Page 597. Is it 8597, Council?
8597, yes.
Eight 599 863
597.
Please, if you don't mind. Yes, yes, I'm here now, yes.
So this is a printout, a public register on Mr. Khan from the DFSA. And what we can see there is that while he was at TABARAK, it might be a little faint, it is on my printout, but what we can see is TABARAK Investment Capital Limited. He was an authorised individual. He was finance officer and senior manager. Yes?
Yes.
So you agree that he was a senior member of your management team?
Yes, he was.
Thank you. Now, just tell me, I seem to have some back here. I don't know if somebody.
Pardon, what do you have, sorry? There is some echo or something?
You have a problem, Ms. Stewart?
Yes, no. I seem to have some feedback. Ah, it's been sorted.
Okay.
Right.
Good.
Okay. So at the time, you had a tight management team. I think there were 4 individuals, were there, in the management team? And how many staff did you have altogether at the time, give or take? You may not remember exactly.
I don't really remember, to be honest with you. 8, 9, maybe.
Okay. Just describe to me your offices. I understand that they took up perhaps 1 floor of the Burj. Is that correct?
No, of course not. Burj Daman? No. We don't have 1 floor. I wish.
Sorry, describe your offices and their layout at the time.
My office is still at the time and until now present. It's only 2,240 square feet only.
Yeah, so it's quite small.
Yeah, it's small, yes, not big office, yes.
And so you enter your office, by which I mean the TABARAK office, and what, there's a small lobby area?
No, we have a small, as soon as you enter the office, there is a waiting area here for 4 people, and then the reception will, of course, entertain whoever comes.
And your room, where's that located? If you're walking into TABARAK's offices, where's that located?
How do I do it for you? I wish. So you enter, you knock on the door or press the bell, you enter. There is, if you have to wait in the sitting area on the right side. If not, just in front of you, you see the meeting room.
Okay, and your office, where's that?
My office on the back side, the back of the office, this side, the other side, not this side, the other side. If I knew that, I would have taken a video. My office is in the back and the meeting room is in the front.
At the time, as you walked in, your office was the first office on the right-hand side, or?
My office right in the back. Nobody can see where my office is.
Okay. Is that at the moment or at the time?
Until now, still. We haven't changed the office. It's still the same.
Right. Okay, now I'm going to go through some events in I'm hoping chronological order. We've had over the past few days quite a bit of jumping around between dates, so I'm going to try and keep it simple. Now, for context, I'm going to touch on meetings and emails in which you weren't directly involved, but in some cases, the detailed contents of those emails or of those events are going to be considered when I cross-examine Mr. Thurner and Ms. Zavialova. Now, so we go from the beginning. As you will have heard, it's the claimant's case that it was Rudolph who caused HUOBI to get in contact with Mr. Thurner, yes? And I don't think it's controversial that there was a meeting at TABARAK's offices on the 16th of December. On TABARAK's side, it was attended by Mr. Thurner and Ms. Zavialova. And that was the first time that this meeting was the first time that Mr. Al-Ali met either of Mr. Thurner or Ms. Zavialova in person. I don't know if you've heard Mr. Al-Ali's evidence. Have you?
Yes, I did.
Okay, so to summarise, he said that this was a general introductory and exploratory meeting concerning really what HUOBI and TABARAK could offer each other in general. Now, amongst other things, Mr. Thurner said that TABARAK had provided crypto custodial services for clients in the past, and they were open to doing so in the future. That's to paraphrase what was discussed. And Mr. Al-Ali and Mr. Thurner, they also discussed HUOBI's needs regarding the sale of the Bitcoin to the buyer. Mr. Al-Ali, he explained that he would have explained by then that HUOBI's standard process wasn't acceptable to the buyer, and that process was one whereby the buyer would deposit the funds with HUOBI first, and then they'd get their Bitcoin, because the buyer wanted the Bitcoin and the buyer's payment to be exchanged simultaneously. However, of course, HUOBI wouldn't transfer the Bitcoin to the buyer without payment. So Mr. Al-Ali, he was exploring whether TABARAK could assist, so as to ensure that the Bitcoin weren't. Sorry, Miss Ahmed, I see you scowling.
I'm not scowling. I'm just listening to where the question is. This is cross-examination, not closing submissions, and I'm wondering whether or not this is appropriate or whether it's simply a distraction. That was, and well, maybe
what Ms. Stewart has said she wants to do is to establish a context. She accepts that in a number of instances this witness was not present, and having established the context, she will be putting certain propositions to Dr. Ahmadi, which no doubt will be designed to seek to establish the claimant's case that Mr. Turner was acting in the course of his employment with TABARAK. Now, Ms. Stewart, don't be too lengthy with your context setting, okay, because otherwise Ms. Ahmed's reaction will become justified. But for the moment, you can carry on with your context building.
Of course, I was just wondering whether or not it was cross-examination or closing submissions, but I hear your point. Thank you.
So Mr. Al-Ali was exploring whether TABARAK could assist so as to ensure that the Bitcoin wasn't transferred to the buyer before the payment was received and vice versa. And Mr. Thurner, having confirmed that he could assist, it was agreed that TABARAK would provide HUOBI with a proposed process. Now, and I know you disagree with this, but Mr. Al-Ali's evidence is that on his way out, Mr. Thurner introduced you to him. Very simple introduction, nothing more than that. Maybe it's because of that that you don't remember the introduction. Very short. Yes?
I don't remember that I met Mr. Al-Ali for 3rd of February. As far as I know, I don't want to give you a wrong answer because I swore him off. So as far as I know, that I only met Mr. Al-Ali on 3rd of February.
Thank you. Now, after the meeting, as we know, Mr. Thurner emailed Mr. Al-Ali to follow up on what had been discussed, and in particular, Tabarak's proposed process for the transaction. And if I could take you to 889.
889, yeah?
Now you, and I accept you're not copied in on that, on this, but Ms. Saviolova, your employee, Tabarak's employee is, it's titled Process and Handling Digital Asset Sale. And he says, as informed and agreed, we herewith place the way how business between you two parties could work. We have, and then it's confirmed that Navicon and Evgeny Morozov are already running accounts with Tabarak. So they're already clients of Tabarak, yes?
No, they're not clients. I declined that.
So you're saying
I'm sorry, I can't hear that answer. He's too quiet. The witness is too quiet, my lord. If you wouldn't mind speaking up.
The file, mashallah, huge, so it's covering the mic.
It's almost a mumble. I'm sorry, I just can't hear some answers.
Sorry, yes, I said no, I declined this.
So is your evidence that at the time neither Navicon nor Mr. Morozov had accounts with Tabarak, or in other words, that neither of them were clients of Tabarak?
Yes, neither of them were clients of Tabarak.
And is it your evidence that neither of them have ever been clients of Tabarak?
See the discussion, is it yes or you want, or I can explain?
Well, if they were if either of them were ever clients, when were they clients?
No, they were never been client. This is my answer. It's not changing, definitely. But then they were discussing with Mr. Turner as one of the proposed potential client for Tabarak. The same thing. This is how I came to know by Mr. Turner that initial discussion was to become client, but they never been onboarded as client for sure.
Right. Okay. On you go.
So there is. So Mr. Thurner recommends that HUOBI should run an account with Tabarak. And then we're familiar with, I think, the rest of this this email. And then there's a suggestion in here that there's a proposal by Mr. Thurner that the partners will sign an SPA agreement. And then but the key points that emerge from this are that apart from the fact that Navicon and Mr. Morozov are confirmed as clients, is that this relates to the purchase of Bitcoin for fiat, that the purpose of the proposed process is clear, namely, we can see it below. So it's near the end of the paper that no harm will of parties take place, meaning that Tabarak's role in this and the purpose of the process was to ensure that Bitcoin wasn't transferred to the buyer before it was paid for, and vice versa. Would you agree with that?
I was not copied on this email. I don't know what they were discussing anyway. I wonder why I was not copied at the beginning of the email.
Okay.
Well,
What says
Mr. The document is there. It contains the words that we see, and
Yeah.
the import of those words are really not something that this a witness can deal with. We can all see it, and we can hear submissions as to what it conveys.
Yeah. And we also see in this document the reference to a TABARAK wallet, and that's all I'm going to say. You'll be grateful to know on this email. Now, if we go to 864 now.
yes.
We know that this shows that on the 16th of December, also after the meeting in TABARAK's offices, Ms. Zavialova, she sends Mr. Al-Ali an email titled "Documents to open an account at TABARAK." There's a list of documents, and I don't think that there is, it's in dispute that on the same day, HUOBI sent everything that was requested of them by Ms. Zavialova. Now, we know as well that if we go to 894,
yes,
that Ms. Zavialova sends HUOBI the account opening agreement, and at that stage there was no addendum attached. Now, if we go to the actual account opening agreement, we will see and that's at the next page, 895. Have you got there?
yes, yes.
Halfway down, TICL services. And then it lists a range of, at the end of that first paragraph, it says, as well as the following: custodial services. Yes?
Yes.
Now, in very broad terms, if an individual is arranging or providing custodial services, that means that they're ensuring that an asset is under the, or if TABARAK was doing this, that an asset's under the custody of TABARAK, which means that it was TABARAK's job to keep it safe. Yes?
Unless if the asset is being approved, what TABARAK can do, yes. One of the assets that we are allowed to handle, yes, definitely.
And there's nothing here in this agreement which that says that TABARAK doesn't provide custody service in relation to crypto-related activities.
Because we don't do, that's why we don't need to mention
it. Now,
Ms. Stewart, I'm getting a little bit concerned now about the approach that you're taking here.
I'm laying.
But you see, it's a matter for me, ultimately, on the evidence I've heard from those who were actually participating in the relevant events that led up to the transaction on the 3rd of February and what happened during that occasion, to decide a number of legal questions which are very important to the determination of this claim. And this witness was briefly at the meeting on the 3rd of February. In large part, he wasn't copied into emails, and he didn't participate in WhatsApp transactions. And I'm getting increasingly uneasy about the technique you're adopting here.
I would, if you would bear, if your lordship would bear with me, I hear where you're coming from, but there is a purpose to this.
Well, at the moment, I'm losing faith quite quickly in the idea that there is some legitimate purpose in this. I mean, why are you not able?
Question.
Wait a moment. Why are you not able to put a overall situation to this witness and ask him in respect of that the questions you want to ask? Instead, we're having an elaborate detail. You're asking him to look at these documents, and it's not a very quick read through. You're pausing on this and that aspect of these emails and the like, and you're going to have to, I'm afraid, you are going to have to compress this process and bear in mind the unease that I have about it.
Your Honor, can I say a word as well?
No, I'm sorry, Mr. Dr. Ahmed. No, I'm afraid not. I'm the referee.
No, I'm sorry, Your Honor. I'm not about your statement. Whatever, but maybe I'll leave it for later on.
No, I think, and you have your counsel's there, and your counsel's in a position to make submissions, and she can re-examine you afterwards to follow up various matters. So don't be concerned about that. Could I ask the transcriber? Could I ask the transcriber, the stenographer, how near are we to a break, the usual break that we have?
As I say, I'm not your usual transcriber. I'm just here for today, and I saw on the timetable 1.5 hours. We're literally 5 minutes or 4 minutes away from the hour and a half we've been sitting.
Right.
For me to need a 10-minute break, my lord.
I've got one question that actually I was trying to get to on the opening agreement. Dr. Ahmadi, you were aware that the account opening agreement had been sent to HUOBI. You were either told about it in advance of it being sent, or you were told about it soon afterwards by Mr. Thurner, weren't you?
I was not aware.
That might be a good point to stop.
Right, it's a 10-minute break, if I recall. So we shall resume in 10 minutes' time. That'll be about 12, 13 minutes past the hour. Thank you very much.
Thank you.
Could I just mention this, Dr. Ahmadi?
Yes,
I say this to every witness. Until you've finished giving your evidence right at the end of the process, you must not talk to anybody about this case, whoever it is, whether it's lawyers, any business associates, nobody, not even your wife. You keep all this to yourself until you've finished. You understand? Thank you very much. Right. 10 minutes. Thank you.
Thank you very much. Now I changed my microphone. Now I think you can hear me even better than before. Can you confirm?
That sounds much better.
Yeah.
Good.
I have good one. Professional microphone now.
Okay, that's very good. As you know, there's a transcriber taking everything down, and so it's important to hear us, but I think we can hear you very well now.
Now she'll be happy. No worries.
Thank you very much. I appreciate the extra effort.
Thank you.
Now,
I told you the mic was moving while I'm moving the file. That's why, the reason why.
Ms. Stewart?
Right. it's true, is it not, that TABARAK wants to become a client of HUOBI, and the reason that TABARAK wanted to become a client of HUOBI's was because there were TABARAK clients who wished to hold and trade in digital assets, and by having an account with HUOBI, TABARAK would be able to trade in digital assets on their clients' behalf.
No, it's not true.
Now, you weren't copied in onto the emails I just described, the email I just described, but if we go to 8316.
8316. 8316.
Now, have you got that?
Yes, it's in front of me.
So the title that will have appeared in your inbox is New Bitcoin Wallet address according to today's meeting, handling process. Now, this email clearly relates to the purchase of Bitcoin for fiat. It outlines a process using a TABARAK Bitcoin wallet address, doesn't it?
I didn't even know that TABARAK has a Bitcoin wallet, to be honest.
And what you're being asked to agree is the contents of this email. This email contemplates a transaction which will involve the use of a TABARAK wallet. That's what it says. And Ms. Stewart, what's your follow-up question on the basis of that?
And reading this email, you would have understood that the purpose of the process set out in this email was to ensure that the Bitcoin couldn't be transferred to the buyer until HUOBI was assured that it would be paid for the Bitcoin. That's what you would have understood, and what you did understand by reading this email at the time.
I would have understood it if I read the email at that time. It's true I was copied, but I don't remember I read the email.
You don't remember reading this at the time?
No, not at the time, only during the proceedings.
Right.
Right. Now, we haven't been provided with any evidence with any electronic correspondence between you and Mr. Thurner before this 20th of December email, but I'd suggest to you that it's improbable that he would have simply copied you in on this out of the blue. By that time, Mr. Thurner will have informed you of his discussions with HUOBI.
He should have informed me by then. I mean, he should, but until now, until that email comes, I didn't have any idea what was going on at this moment.
So you do accept now that you did read the email at the time?
Yes, I didn't read the email at that time, definitely, yes.
Right.
Yes, the witness is saying he did not read it. That's what his evidence is. Yeah.
Yes. Well, I suggest to you that this, as I said, this wasn't simply out of the blue. Mr. Thurner told you about discussions with HUOBI. He told you about the buyer's wish to buy Bitcoin from HUOBI, and that HUOBI was seeking assistance from TABARAK on a mechanism to ensure that the Bitcoin wouldn't be transferred to the buyer until HUOBI was paid. Correct?
Mr. Turner, if he briefed me on anything, it would have been definitely assisting them out of the scope of TABARAK activities. Maybe outside TABARAK activities, line of activities, yes, could have, but he knows and I know we cannot do this businesses within TABARAK.
Now, by this time, you and Mr. Thurner, or around this time, you had discussed how a relationship with HUOBI could be beneficial to TABARAK as well. And the ways in which I suggest to you, you thought it could be beneficial is that HUOBI would set up a dirham account with TABARAK, so TABARAK would be able to earn fees on transfers, correct?
See, Ms. Counsel, I know there was negotiation and discussion going on between...
I'm asking you a question, and the question is, the relationship with HUOBI could be beneficial to TABARAK because, firstly, HUOBI would set up an account with TABARAK, and so TABARAK could earn fees on transfers.
I'm wondering whether Mr. Chu would allow the witness to finish, please.
Well, no, wait a minute. We've, as sometimes happens, there's been a little bit of toing and froing. Let me just intervene for a moment. Dr. Ahmadi.
Yes.
The question is this: do you accept and agree that if HUOBI became if TABARAK became a client of HUOBI, this could be beneficial for TABARAK because they could be involved on behalf of their clients with Bitcoin transactions?
Your Honor, my answer is that I never had any idea that TABARAK is going to be client of HUOBI. It's the other way around. That's all what I understood.
Well, just pausing for a moment on the hypothesis that I put to you that TABARAK becomes a client of HUOBI, do you agree that if that came about, it could have been of significant benefit to TABARAK, because TABARAK's clients that would want to trade in Bitcoin could do so with TABARAK using HUOBI's expertise and established reputation in the Bitcoin financial service.
I don't agree.
You don't agree with that? Now, but I think you were going on to say that if it were the other way around, so if HUOBI became a client of TABARAK, then that might be beneficial to TABARAK. Is that right?
Yes, that's correct. So,
and how would it be beneficial to TABARAK?
They will be beneficial. We can manage any sort of assets they have. We can be their investment firm. We can invest any assets besides cryptocurrency. This is for sure. We discussed that with Mr. Turner. Why HUOBI wants to become a client of TABARAK for businesses that we can manage their assets as per the authorities and license we are. I mean, clearly, it was not mentioned because to manage their cryptocurrencies. This is out of the question completely. We can bring clients that we see future business with. So future business is with HUOBI is not only cryptocurrency. Maybe they have some assets they want us to manage. They want to manage for some of the real estate transaction that we can make fees out of services that we are allowed to provide them.
And looking at real estate transactions, just by way of example, HUOBI is a business involved in cryptocurrencies. Therefore, any property transaction would necessarily involve cryptos, wouldn't they?
No, not necessarily. Maybe the directors of HUOBI, the owners of HUOBI, have their own personal real estate transaction they want us to assess. We will be more than happy to do that. Any business we are more than happy to do with them except cryptocurrency. I'm very clear from the beginning.
The point is that the relationship would enable TABARAK's clients who wanted to trade cryptos to do so whilst enabling TABARAK to earn revenue from this. And that could be, and TABARAK could earn such revenue by perhaps providing some kind of a custodial service, by using TABARAK accounts, which TABARAK would earn fees on transfers, or by TABARAK opening an account with HUOBI, HUOBI MENA, or HUOBI Global, and TABARAK trading on behalf of their clients with that HUOBI entity. In theory, at least, you would accept that TABARAK would earn fees from that type of activity.
No, it's incorrect. You've already asked me this question. As I said, I had no idea that TABARAK was going to open an account with HUOBI. This is one thing. Secondly, as I said, when we said we open an account for HUOBI, excuse me, I clearly explained now to you and the honorable judge that we doesn't mean what we cannot open account for HUOBI for any other transaction besides cryptocurrency.
Right. Now, Mr. Thurner will also have told you around this time, either before or shortly afterwards, that HUOBI had already provided all the documents that TABARAK had requested of HUOBI in order to open an account. Correct?
No, it's not correct.
Right. If we go to 8317. Now, this is an email where Mr. Saxena has basically replied all to the recipients of the previous email I took you to. So that previous email I took you to, Mr. Qadir Khan, your finance director, had also been copied in on it. And in this email, that's a reply all, Mr. Qadir Khan and is also copied in, as are you. So this is another email.
Yeah, that's
yes. Go on. We can see that. And now, what's your point, Ms. Stewart?
So the point being is that at this stage, you had another email which has got Bitcoin in the title, and you still haven't contacted. You still haven't written back saying what's all this about, what's going on.
At the end of the day, still HUOBI is not client of TABARAK. So whatever discussion going between them and Christian, even though I am copied on, it will not be still an interest of me to interfere, because still they are not client of TABARAK. So going on between HUOBI and member of my staff, I've been copied on it. It's okay. Let them. At the end of the day, the final say, a final execution has to come to me.
So if we go to 319.
Yes, I am 319.
You're copied into yet another email from Mr. Saxena. Same title and short email saying we are trying to arrange 0.00125 Bitcoin to the wallet address provided. So at that stage, you cannot have been in any doubt that this involved Bitcoin, and that this involved, which is of course a cryptocurrency, and that this obviously involved TABARAK. Can you?
I said it doesn't involve TABARAK because HUOBI is still not a client. So my answer will be the same. Previous your question will be the same. I wouldn't. We cannot provide them any services. They are not yet onboarded as a client. So as I said, about discussion going between. Can I please finish?
Yes, go on, please.
As I explained to you before, whatever conversation and discussion going on between member of my team and potential client or prospect of client, they can exchange a lot of email. They can even copy me. I know for sure at this moment HUOBI is not a client, so they are talking to each other. At the end of the day, when it comes to final execution and everything, they will have to come to me. Then I will interfere here. Is either what you did right, what you did is wrong. At the moment, it's a discussion like any other discussion with any other potential clients. He meets clients more than, he meets different clients every day, not only HUOBI. He was meeting a lot of clients every day, so emails was going flying around. It doesn't mean that we are supposed to provide services to this particular conversation.
Well, the natural thing to do, Dr. Ahmadi, if we were to believe your case, which is that TABARAK was not to be involved in crypto assets and had an internal policy prohibiting any activity with crypto assets, would be to send an email, would be to contact Mr. Thurner, to send an email saying, we don't do this.
I don't think he's ever said that there was an internal policy, Ms. Stewart.
There is no internal policy for that. There is full stop. We are not allowed to provide any cryptocurrency. We don't have to have internal policy to say, oh, we are not allowed to provide internal policy, cryptocurrency.
You could have, at any stage, Dr. Ahmadi, looked at these emails and said, well, we don't even have, TABARAK doesn't have a Bitcoin wallet address. You didn't do that, did you?
I did speak to Mr. Turner. I said, what is going on? He explained, he said, well, let me finish, please, if you don't mind. You're asking a question. So I did, it's not interfering. I said, what's going on with the emails with this particular? He said, no, we are still trying to bring them as a client of TABARAK as per our requirement. What he's discussing with them, wallet, and all these things, I will come to know about it later on. It's fine. At this moment, as I said, it's discussion going on between a member of my staff and a prospect. They can discuss about wallets, about crypto, anything. But did we really agree on that? Did TABARAK really authorized person agreed on that, sign any contract? This is where we jump in.
Well, I think that will be a legal question. But the point is that you knew at this point that HUOBI was wanted, at the very least, wanted to become a client of TABARAK for the purpose of a crypto-related transaction. Do you accept that?
No, I only accept that HUOBI wanted to become a client to utilize the services that we have for future businesses, not for crypto.
Now, the reason you didn't write back or contact HUOBI, or even the reason there's no internal emails about this or ones that haven't been disclosed, is because none of these emails were a surprise to you. You were fully aware of the nature of the transaction that TABARAK was becoming involved in, weren't you?
First of all, I never had any contact with HUOBI. I don't know who they were, first of all, because I never interacted with them previous than the 3rd of February. If anybody has to interfere into this to talk to them, is the front person or the front guy, which was Mr. Turner. Mr. Turner is very well aware that we are not allowed to provide any cryptocurrency services to anybody. We are not authorized. We cannot. We don't have the expertise. We are not. We don't have anything to say. We never done this transaction. All in my mind was HUOBI becoming client, regular client. We do normal investment for them, whatever they need, as per our scope of license. That's exactly my understanding.
Right. Now we move into 2020. By this stage, Mr. Thurner had been keeping you updated on what was going on, hadn't he? He told you that that HUOBI wanted TABARAK to come up with a process to ensure that Bitcoin would not be transferred to the buyer before payment.
He never discussed this with me.
Right.
You're going a bit quiet again, Dr. Ahmadi, forgive me. Yes, you went a little bit quiet.
Shall bring it closer to me.
Lovely. Okay, good. Thank you.
Now this is, can I take you to page 371?
So this is 8371.
Yes.
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 This is an email dated the 15th of January, as we can see. Now,
Yeah.
you again are copied into this email, aren't you, Dr. Ahmadi?
Yes, I was, yes.
As is your financial director, Mr. Kadir Khan, yes?
Yes, he was there as well.
And this attaches a raft of information in order to fulfill HUOBI's KYC requirements for TABARAK to become a client of HUOBI.
My understanding was the other way around, honestly speaking. Finally, I thought they sent an email for HUOBI to provide us with the missing documents for them to open account with TABARAK.
But all of the documents that are attached are TABARAK documents. And we can see those documents from page 372 up to page 413. I won't take you to each of them, but that's just for reference.
Yes, I understand. I've seen them, yes.
And this includes a copy of your passport.
Yes, I can see it, yes.
And the Wolfsburg Group correspondent banking due diligence questionnaire.
Okay.
And we can see at page 413 that this Wolfsburg questionnaire is certified by Mr. Thurner and Mr. Malik. Sorry, that's page 413.
413, yes, I'm here. Yeah, so this has been certified by Mr. Turner. However, it's not being certified by Mr. Malik, and during the witness statement of Mr. Malik, you can discuss this with him, because this one has done without the knowledge of Mr. Malik, who was our compliance director.
So this was you were copied in on this. Mr. Thurner was not trying to hide anything. This was not an unauthorized certification in relation to the Wolfsburg questionnaire, was it?
Can you elaborate more about your question, please? Can you say it more? So
this was copied to you, this email.
yes.
This email attached to it, and it's titled Wolfsburg. You can see it in the title of on the email of the attachment.
Yes, I can see it, yes.
At no point did you go back to Mr. Thurner or to HUOBI, for that matter, to say that Mr. Thurner was not entitled to send this Wolfsburg report.
First of all, as I mentioned before, I never had any communication or any contact with HUOBI. I don't know any individual of them. Secondly, this Mr. Turner, he might have sent this one. Sometimes when the client come approach us, especially corporate, when we ask for the due diligence documents, they also ask for our due diligence compliance to know who they are dealing with. But that one doesn't say that we, TABARAK, or me personally, that I give permission to Mr. Turner to go and try to open our account, TABARAK account in HUOBI. I never permitted this. Sending our license, e-commercial license, article of association. This is a lot of, even if you want to make a work visa permit for anybody, they will ask you for this type of documents.
Right.
Holders, license and everything. So I thought this is normal standard. People, they wanted to know who they are dealing with.
Now, also on the 15th of January, but a little bit later, we go to 367. I have another email.
Yes.
Now, you aren't copied in on this, but your financial director, Mr. Kadir Khan, isn't he?
Yes. And Mr. Kadir Khan, he is the financial director of Mr. Christian Turner's new company as well now, for your information.
And Mr. Kadir Khan at the time was DFSA authorised individual, wasn't he?
Yes, every finance officer has to be DFSA authorized.
Yeah. And we can see that this email concerns a special TABARAK's bank account details and a special code for using a testing session. And then in terms of TABARAK's bank account details, we can see on the next 3 pages different details depending on whether the transfers are in dirham, US dollars or euros.
I can see that, yes.
Yeah, and there was no pushback when Mr. Kadir Khan was copied in on this. There was no pushback from him that you're aware of. He didn't say to Mr. Thurner, "What are you doing?" He didn't say to HUOBI, "Hang on a sec, what's going on here?" Did he?
No, nobody informed me.
He knew that you authorized this activity.
Which activity you're talking about?
The activity involving HUOBI, and in particular, at this point, a testing session for a Bitcoin transaction.
I did not authorize.
So at this point, Mr. Thurner is of the belief that this is all fine. Your finance director thinks that this is all fine. Ms. Avialova thinks this is all fine. TABARAK wasn't a large company. It's inconceivable, I'd suggest, that you hadn't authorized this. And the communications with HUOBI about becoming involved in Bitcoin transaction.
I said that to counsel. I did not authorize that. And also, there is also a big question mark. Even either emails from HUOBI to TABARAK or TABARAK to HUOBI, only few of the emails have been copied. I will not put in all the emails. I'm not sure why, but this is it.
And then we have another email, for the record, that's at 8419. You're not copied into this, Dr. Ahmadi. I'll let you get to that.
Yes, I'm here.
But again, Mr. Kadir Khan is. And this is where Mr. Thurner is emailing HUOBI with TABARAK's proposed figures for the addendum. Now, if we go to those, to the addendum on page 420.
Yes, I'm here.
We see reference to OTC business TABARAK stroke HUOBI and a proposed fee which is measured by reference to the XE chart, don't we?
You're referring to 8420?
Yeah, so 8420,
Yeah.
It's titled Addendum to Account Opening Agreement.
Yeah.
And we see the last of the bullet points is OTC business TABARAK stroke HUOBI plus 1% fiat on XE chart.
I can see that, yes, I can see that.
Yep. So XC,
during the trial, to be honest with you.
an XC is a term that's only used in crypto transactions, isn't it?
Which one? Can
XC.
One?
It's it's the use of measurement.
With the fee structure you're talking about, or different line?
Well, if you look at the last bullet point,
Yeah.
it says OTC business TABARAK stroke HUOBI, and then to the right it says plus 1% flat on XE chart, and this Stuart is putting to you that XE chart is concerned only with crypto assets, cryptocurrency, and she's asking you, were you not aware of that?
No, I was not aware. I don't even know what XE to be honest means. What does it mean? And this document I've only seen it during the trial.
Mr. Qadir Khan was clearly aware of this. Mr. Qadir Khan didn't object. Your finance director didn't object to this addendum being sent to HUOBI, did he?
I'm sure he didn't, but Mr. Qadir Khan also doesn't. He's only finance officer. He doesn't have the authority to say yes or no. He should have come to me and asked me. But nobody came to me and asked me about it.
Now, again, if we go to the next page, 421, you, Mr. Qadir Khan and Miss Zavialova are all copied in by Mr. Thurner to an email to HUOBI. You accept you were copied into this email?
Yes, I can see I'm copied, yes.
So Mr. Thurner, he wasn't hiding anything from you, was he? Obviously not, as he was copying you in.
Maybe he was hiding from me.
Right. Now, the email title in capital letters at the top is Final Procedure to Start Business. We go to that email and we can see at the top that it says, after reviewing all of past and history and discussions, this is the procedure we would be able to satisfy all involved parties. So Mr. Thurner's come up with a proposal. The first couple of bullet points, Evgeny, the buyer, has placed verified funds with us at a correspondent bank in Europe. He and a partner also verified funds here in UAE with 3 major banks, close to 50 million dirham. So what Mr. Thurner is conveying here is that TABARAK has verified the buyer's funds, both at TABARAK's correspondent bank in Europe and also funds in the UAE.
That is the procedure they are talking about. This is the procedure we would be able to satisfy.
No, I'm asking about those first 2 bullet points.
Evgeny has placed verified fund with us at corresponding bank account.
So that's saying that TABARAK has verified, those first 2 bullet points in a nutshell are conveying that TABARAK has verified funds with TABARAK at a correspondent bank in Europe and has also verified that the buyer and a partner also has funds in the UAE. Do you agree that that's what it says?
No, it's not, doesn't say. I disagree. My understanding from this email, if you see, this is only the procedure. It's not that we have verified If like we are going to, it's what Mr. Turner means that as per this procedure, Tabarak, Mr. Yevgeny will place the funds within our corresponding bank, and then he and partner also will verify funds in UAE, 3 major banks in UAE. That is the procedure. At the end of the day.
Right. Okay. So you're saying this is the proposed procedure. Now, what this says is Yevgeny has placed verified funds. So that's the past tense, has. And then if we go to the third bullet point, that says HUOBI will show Bitcoin. So what that's showing is that the verification has already been carried out, and the next steps will be that HUOBI will show Bitcoin and so on.
What the email says.
You are denying that?
It's not. I'm denying that. It's not that. This is the procedure that's been laid by Mr. Christian Turner. It doesn't mean that. First of all, it doesn't mean that it is the one that we agreed, we approved. That procedure. This is where you ask me where I jump in. This is where I jump in.
Right. Now, if we go to the third bullet point, we have the mention of, again, of Tabarak Trezor wallet. So that's Mr. Thurner saying that Tabarak has its own Trezor wallet, correct?
Maybe no, this is incorrect. Maybe as I mentioned earlier in my early statement, I have no idea that Tabarak has a Trezor wallet. Secondly, maybe he's talking about his own wallet.
Right. Next. And then you can see from the fifth, well, we can see from the third bullet point down that what we're talking about is a transfer in relation to 500 Bitcoins. Yes?
Yeah,
And then the second to last bullet points talks about HUOBI transferring Bitcoin to the Tabarak Trezor wallet. Yes, you see that?
Yes, I can see that. So that just says this is the procedure laid down by Mr. Turner. It's not that something has been happened, fund has been verified, money has been verified. No, this is the procedure proposed by Mr. Turner to HUOBI.
Thank you. Copying you in because you're the CEO of Tabarak, the company that Mr. Turner's working for, because this all involves Tabarak, doesn't it?
That doesn't mean Tabarak has agreed onto this. Doesn't mean that I and Tabarak agreed on this process or procedure.
Okay, but neither you nor anyone from Tabarak contacted HUOBI at any stage saying Tabarak doesn't do this type of business.
No, I spoke to Mr. Turner personally.
There is no evidence of that whatsoever, is there?
No evidence. He sits next to my office, so we talk every day in different sense. So
exactly. Yes, exactly.
When I saw this email, I confronted Mr. Turner personally. I said, "What is going on? Hang on, what's happening? What is going on? That is not what we agreed for HUOBI to become a client." And thanks, of course, if you want to take me further, then we can.
Moreover, nobody from Tabarak contacted HUOBI saying that actually funds hadn't been verified, did they?
The only person is allowed to contact or permitted to contact HUOBI, since they are not a client, is Mr. Turner, because still he is the point of contact of Tabarak. When I expressed my dissatisfaction with this email, he should have picked up the phone, and he told me I'm going to discuss with them. Picked up. Nobody else can speak to HUOBI. The finance officer, the finance department, they don't have the right. Compliance doesn't have the right. I don't know the clients yet, who they are. I know HUOBI, I hear about them, but they are not a client at this moment. Still, they are not a client of TABARAK. So all these proposals and emails change. Excuse me, can I finish, please? I give you a chance to finish. All this email and proposal exchange between Mr. Christian Turner and HUOBI and everything, the procedure, it doesn't mean that TABARAK agreed in all this. It doesn't. Is there anything that I said, yes, I agree? Is there any email from me saying this, this is a good idea, let's come? No, there is nothing. So I interfere personally.
Can I take you,
Thank you
to 422, please?
Yes.
This is another email that both you and Mr. Qadir Khan are copied into.
Yes, it's the same continuation of the same subject they are discussing.
Yes, quite.
Yeah.
And in fact, the title says, request for first transaction of 1,000 digital asset -BTC. So by that stage, things were really moving forward, weren't they, with this transaction?
Even if they are moving forward, still we will not, TABARAK will not execute me, TABARAK, as a decision maker, because HUOBI is still not a client. Still not. As far as I'm concerned, it's still Mr. Turner is negotiating with them. Some sort of any proposal could be Bitcoin or anything.
So you are actually allowing him to negotiate?
It's not allowing him to negotiate about cryptocurrency. As I discussed with you before, he knows, and Mr. Turner knows very well, we cannot onboard any client that will do cryptocurrency transaction. So discussing about that, as I said, discussing, exchanging proposals that between Turner and HUOBI, still they are not a client of TABARAK. Still, I am not really worried that we are going to accept them as a client to do this business. At the end of the day, it will come to me. So that what I'm trying to say is there is a lot of email exchange between all parties. Doesn't mean that I am reading every single email, and it's like any email goes between one of my staff and a potential client.
So, right now, on your case, there was an unwritten prohibition on anything to do with cryptocurrencies within your firm, correct?
I think I answered this, counsel. I told you before, we don't need to have a written because we are not allowed as per our license.
Unwritten.
Written or unwritten, we are not allowed. We have certain activities in our license. We need to follow them, and that's it. We follow what we can do only. Written or unwritten, this is something we really need to worry about.
But on your case, you can't do anything to do with cryptocurrencies. And yet, despite all of these emails that you're copied into, which, for example, have the word digital, the term digital asset in their title, there's not a single email back to Mr. Turner saying you must not do this. There's not a single contact with HUOBI saying, look, I'm really sorry, but we don't do this. We're happy to help you in other ways, but we don't do this. Not a single thing.
There is no single communication between me and HUOBI. Yes, I agree, because I don't interfere. There was communication between me and Mr. Turner, advising him and stressing that we cannot do that. So it is the responsibility of my senior staff to convey this message to his potential prospect. At the end of the day, still HUOBI is not a client. Had they been a client, I would definitely interfere in every single matter. directors. But they are not, they are the same thing. They are potential prospect. They are thinking to become client and discussing or exchanges emails and proposals.
Adi, thank you.
Yeah.
Round about the 20th of January, a representative from HUOBI brought a signed version of the account opening agreement to HUOBI's office, didn't they? And you knew about that around the time.
I don't remember. 20th of January.
20th, round about the 20th of January, you were aware that HUOBI had signed the account opening agreement around this time, and that the signed agreement had been provided to TABARAK.
I was not aware. Also, having said that, having signed the agreement, were they onboarded? Potential prospect, they can still sign account opening agreement, but they will not be considered as onboarded as a client until they fulfill all terms and conditions. Having said that, if you want me to lie down,
I understand your position on that, Dr. Ahmadi. Now, if we go to 425.
Yeah.
This is HUOBI OTC's standard form for a corporate that would like to open an account with HUOBI OTC, right?
Yeah.
And this, we can see in this, and I will put it to you that you were aware that this had been filled in by Mr. Thurner.
I was not aware that it being filled in by Mr. Turner. I was not even told about
And
it.
if we go, so on page 425, third box from the bottom, type of business, stroke license activities, we'll see that that includes advising on financial products, and it says custody as well, yes?
In credit and custody.
And then if we go to 427,
yeah.
this and part 3 business activities, cross there is fund investing in digital asset and market maker buying and selling digital currency with own capital proprietary trading firm. And you were aware, as I said before, which I know you don't accept, that Mr. Thurner, in his capacity as Director of Investments, had filled this in these terms.
Yes, he filled it in his own terms.
Right. Now, if we go to 449.
449?
Yes.
Yes.
This is an email from Mr. Thurner to which you're copied in, Mr. Kadir Khan and Ms. Saviolova are copied in again. Now, basically, having sent a number of documents, Mr. Thurner appears to be a little cross at having to send any more documents. He says that TABARAK's a registered and licensed bank. He's in effect saying that this should be enough for HUOBI. And then he requires, he says, make our account with you active. So our can only refer to TABARAK's account, can't it?
If this could be as well, I don't know, I'm not sure. I can't answer you that. Our, maybe his own, maybe his TABARAK, I'm not sure really. because I was not aware that we are opening account with HUOBI.
And he refers to having already sent HUOBI's account details with TABARAK in this email.
Where is mentioned? Sorry. And,
So last and regarding third time request for sending your account details with us.
how we send account details and they are not a client of us? This is the question. How we can send account details, but maybe he sent his file reference, could be he's referring to his file reference within TABARAK, because we established internal file reference only.
But at no stage did you, there's no document, is there? There was no contact with HUOBI saying, well, you're not a client, you don't have an account with us.
You mean who contact? Me?
From anyone at TABARAK.
As I mentioned earlier, the point of contact between TABARAK and HUOBI is the staff who's dealing with their matter, which is in this case, Mr. Christian Turner. And as you said, I consider Mr. Christian Turner a senior staff. Of course, senior staff, I trust him. I trust he will do what we supposed to do or he's supposed to do.
And then I anticipate your answer to this, but if we go to 461,
yes, I'm in 461.
Ms. Yalova emails HUOBI copying again Mr. Qadir Khan, giving an account number and TABARAK's bank details for transfers.
I can see that, yes, I can see, but is there any attachment with this email? I can see this
The attachments come at 463, 464, and 465.
Yeah, so that is this is the reference of HUOBI's file with TABARAK, TICL 0101. That doesn't mean that they are, as I said, as I explained to you, anybody approach us, anybody, individual or corporate, they want to open account, we create a reference number internally. That does not mean that they are onboarded as a client. No, that's just for internal references. Then sending our account details at Noor Bank to HUOBI, this is a different story. You see now I'm not copied into this email.
Right, you are copied into the email at 472. As is Mr. Qadir Khan and Ms. Avialova.
Yes.
Now, this was in response to an email from HUOBI Global. And Mr. Thurner says to Zoe Liu, you need to know that we are only on service for HUOBI. And we are not trading anything with you, meaning HUOBI Global. But he provides your passport details and also the passport details of Mr. Yes. Now, what he then says is, board resolution, we don't do anything related to crypto. But then he says, we only do digital asset management. Now, crypto, as I've put to you before, is a type of digital asset, isn't it?
Not from my understanding.
And so TABARAK does do crypto-related asset management.
You're still referring to crypto. As I told you, we don't do anything related to crypto. And I have told you exactly, sorry, I have explained to you earlier in our cross-examining in the morning what we think about digital assets. It doesn't mean that there's a cryptocurrency is involved. Digital asset, what we think is of anything digital, visual digital, PDF, presentation, leaflets, brochures. When you scan it, send it to any other safe place, this is digital assets considered.
So you're asking the court to believe that the reference to digital asset management is what TABARAK looking after clients' PDFs?
No, you are interpreting it a different way. You just want to make everybody confuse your counsel. Let's talk about this email. You're referring 472.
No, I'm asking the questions here, if you don't mind. The next part of the email says.
Stuart.
Sorry.
Do you mind allowing the witness to finish, please?
Well, I'm actually asking the question. So
please allow him to finish.
You are referring to page 8472.
If you'd like to re-examine, if Miss Ahmed would like to re-examine, then she's entitled to. Now it says that the person in charge to handle all issues related to investment and digital asset management, and so HUOBI issues, will be Christian Thurner. And that is consistent with Mr. Thurner's focus on digital assets within TABARAK, is it not?
As I say, it depends what Mr. Thurner was understanding of digital assets. And let me, if you don't mind, can I elaborate on this email?
Yes.
I saw this email. This is the same thing, same story. I called Mr. Thurner. I told him, listen, Mr. Thurner, I'm confused. What's going on? You've been talking about digital assets. We don't do this cryptocurrency. We don't do this. Then say, no, don't worry. Everything will be fine. It's only about onboarding. We will only provide the services that we are entitled to. I relied your message to HUOBI. We cannot deal with any cryptocurrency client or transactions. I was confused, really. That's why I confronted Mr. Christian Thurner. I said, please, you go back to your prospect and tell them that TABARAK does not do this type of things. So the email has been sent, doesn't mean the email has been accepted by the TABARAK top management. Every time I see there is a need for me to speak to my staff, I go and I speak to him to his office. I don't even call him to my office. I said, and I give, either he listens to me or then he does something else behind my back. That's a different story. But I expressed our dissatisfaction with this email to Mr. Thurner. We got nothing to do with HUOBI, because HUOBI, he is the point of contact. I don't contact clients until they become client, official client. Then I have the right to communicate with the client.
Right, thank you. Yes, go on, Mr.
Then we come to the trial transactions. If I can take you to 367.
367, yes, yeah.
This is something I've already taken you to, and this regards to which Mr. Qadir Khan was copied in, and that regards TABARAK's bank account details and a special code to use in the testing session. Now, this was in relation to the first trial transaction, and Mr. Saxena in his witness statement described what that trial transaction involved. And that involved HUOBI receiving 100,000 dirhams worth of crypto from its client, MR. HUOBI sells those to raise US dollars. HUOBI then transferred the US dollars to TABARAK's account, and Tabarak then converted the dollars back to dirham and transferred it to Emma's account. Do you agree that that was the transaction and that's what happened?
This transaction does not involve cryptocurrency transaction. This particular transaction, HUOBI, as per what Christian Turner explained to me, I said, why they are doing this transaction? He explained to me that they wanted to see the competence of our TABARAK banking system, how it works, how long it takes to receive, how long it takes to transfer the money. This is where they did the testing, to see the competence of TABARAK banking system. Nothing to do with the cryptocurrency.
Well, it was definitely in the context of a cryptocurrency transaction, but which you knew.
See, the money did not come from cryptocurrency transaction. It came from HUOBI account to transfer it to real estate escrow agent that they deal with. This is one of the.
Wait a minute, Monsieur. Let him finish, please. Go on, please, Dr. Ahmadi.
Your Honor, it's okay. She can continue saying because.
Can I take you to 8700 now?
Yes, I am in 8700 now.
So, so the first email at the bottom, and I accept you weren't copied into this, but Mr. Qadir Khan was. Mr. Saxena is asking Mr. Thurner to confirm once the funds have hit Tabarak's account, which he does, as we can see at the top. No pushback from Mr. Qadir Khan. I think you'd agree.
Yes, I can agree with it.
Right, and then if you could go to 481.
That's it. Just to see the competence of our work. Yes, 481.
481.
481. Yes. I'm almost there. Yes, I'm here.
So Mr. Thurner is sending an email to Mr. Qadir Khan and you. Dear Qadir, we do have a confirmed transfer order from our client HUOBI. Please execute by earliest tomorrow. So at this point, not only did HUOBI at this point, Tabarak had actually told HUOBI that HUOBI was a client of Tabarak's. Yes?
That is Mr. Turner's own representation. As I said, HUOBI never been a client of Tabarak. That says everything. HUOBI never been a client. Going back to this transaction, when it happened, I confronted Mr.
I'm going to get on to
that.
No,
let him say. Go on, Mr. Ahmadi.
Yes, during this testing session, I was not in agreement of that. I said no, but he said, he convinced me in a way, listen, this is just, they want to become normal client, nothing to do with cryptocurrency. They want to see how our system works. It's just transferring and sending it back to their real estate partner. I said, that is it, do it, and that's it. I was aware of this transaction. However, the transaction has been already executed before even I spoke to Mr. Turner. Then I know it hit our account. This is for fact. Immediately, okay, we received an email from Mr. Turner to transfer it to HUOBI's real estate company. I'm aware of that testing transaction.
Yeah.
But doesn't mean that HUOBI is a client of us.
Now, by the 27th of January, the funds still hadn't landed in Emma's account, so Mr. Saxena is chasing, and we see that at 482, and he copies both you and Mr. Kadir Khan into that email. Yes?
So let's get it up.
And this is 27 January. At the end of the day, the money has gone to HUOBI's real estate account in Dubai. This is where I called Mr. Turner. I told him no more business, this type of business at all. Don't do it again.
Let's go to 485. In fact, what happened was this, that, and if we go to the bottom of 485,
Yes.
it's an email from you to Mr. Thurner and Mr. Kadir Khan, and you say, I believe HUOBI is not a client yet, and I'm wondering how we are providing services without becoming a client. Then if we go further up the page, Mr. Thurner responds, this is all about the testing session we received and now we transfer. When I am back, because he was away, he was abroad at the time, when I'm back, I have a meeting with them, and also we will have the account opening fee, ! So Mr. Thurner, he realizes that your concern is that the account opening fee hasn't been paid, doesn't he?
Account opening fee plus other missing compliance document that they have not provided. It's not only about account opening fee, both. And you see here from my email that I'm not happy. I did not agree with that transaction. I'm not happy Mr. Turner conducted this transaction. And you can see that. This is why I told you I spoke to Mr. Turner after my email as well.
I'm not denying the contents of your email. Now, if we go to the PS, which is at the bottom of that email, so that's around the middle of the page, yes, it says, also waiting the transfer for my 2 Bitcoin I sold through HUOBI. The exact figure for transfer I sent. Thank you! ! Now, you were clearly aware at that time of this transaction involving 2 Bitcoin, weren't you? Because Mr. Thurner had told you about it.
Yes, I do remember, yeah, he told me about it.
So you were aware that TABARAK had instructed HUOBI to convert 2 Bitcoin to fiat currency.
No, see, this yeah, continue, sorry.
Yes, you finish your question and then we'll hear the witness's response. Go on, Ms. Stewart.
And that TABARAK transferred 2 Bitcoin to HUOBI. You're aware of that?
This is why I spoke to Mr. Turner about 2 transfers. The transfer of HUOBI that he said is already been 900,000. They want to see the compatibility of how we are compatible for that services and everything. In the same time, he also told me that there is small amount that been transferred to account of TABARAK. It is intended to be for BTC, but it will not mention that it is BTC transaction. That is also that 2 items I raised my dissatisfaction with disapproval with Christian about the 100,000 and about this small amount of his BTC transaction.
And you agree that receipt of that the funds for the Bitcoin were received in TABARAK's bank account?
Yes, I'm aware that it received both of them.
Now, although HUOBI didn't know at the time, it materialized that Mr. Thurner had lent TABARAK his own Bitcoin for the purpose of this test, hadn't he?
I don't know. I don't have any idea. Sure.
And in this email to you of the 27th of January, in the PS part, he wants TABARAK to transfer to him what's owed to him. He wants repayment for that loan.
Loan, I don't know if it was a loan or anything. I have no idea if it was a loan. All what I know is there's 2 transfers, only a test in which I then never approved, first of all. Secondly, have already been done before even I spoke to Mr. Turner about my dissatisfaction and disapproval of this.
And you transferred the money to Mr. Turner from the TABARAK account for the Bitcoin?
Because we already received the money for on his behalf, which is...
Yeah.
Yes.
So you did, yeah.
Yes, we transferred it, but that's it. As I told you, I told him no more, no more this type of things again. So I have, and all the transaction has been done without my authorization and permission and agreement.
No, right, now we come to your response to Mr. Thurner's email of 1541, which is the one with the PS in it. And that comes very shortly after. So that comes at 1613, and we can see your response at 8484. Now I'm going to invite you and your lordship to have a quick look at that, quick read of that email.
Yes.
Which page, please, if you are referring to?
Now,
And the witness wants the confirmation of the page he's to look at.
oh, I'm so sorry. 484.
484, yes.
So it's on that page, nothing else.
Yes.
An email on that page. Well,
Yes.
fine, I will look at it, and I'm sure Dr. Ahmadi will.
Yes, I'm on that page. Yeah, anything for me in the quiet, or you?
I'm just waiting for his lordship.
Just reading the last 2 sentences.
Sure, I thought you're waiting for me.
Yes, thank you. I've read it now. Thanks.
Right, so I'd suggest to you that it's clear from this email that you were bothered about 2 things. Firstly, first and foremost, you were bothered about how, you're concerned about how TABARAK was earning money from these transactions. Indeed, there are 3 mentions in this email to what TABARAK's getting out of this. First of all, to pay the account opening fee. On the first trial transaction, you say, where's our fee on this? And then on the second trial transaction, besides, and that was the trial transaction involving the 2 Bitcoin, besides, what is our commission on this? That was what you were most bothered about, Dr. Ahmadi, wasn't it? How much money you were earning from this?
We did not make money of any of this transaction. All my concern was, first of all, HUOBI, and you know, my as I told Christian here, that cannot be do this need to be client and pay the account opening fee. Yes, pay account. Out of this transaction, we did not make anything. Out of this 100,000 and a small one, we did not. We received it. We sent it exactly the same amount outside.
And that's what you were annoyed about.
No, it's not actually not that. The annoyed is why he did this while HUOBI is not client yet and paid the account opening fee. That is the whole scenario.
And then secondly, you're bothered that there were references to digital assets. And what you're saying is, it's okay to do the transaction as long as you don't make it obvious and alert the bank that digital assets are involved. And that's why you make it clear that the only reference should be to HUOBI's account opening reference, isn't it?
This would be correct, yes, this would be correct, as I said, because we don't do cryptocurrency transactions. Now, all this mess Mr. Christian Turner put us in, I wanted to clear it and explain to him that is not the way that we work. Because on that days, if you see, if I don't want to go further ahead of that, that probably was the last relationship we have with HUOBI, because on 28, I have decided to terminate all relationship with HUOBI. I mentioned that to Mr. Christian Turner. No more, we close the file. Especially after this 2 test transaction without my permission, without my, as they say, not authorization, without me being really satisfied much of what's going on and what Mr. Turner is doing.
Right. Now, at this stage, if on your case you are so bothered about being involved in now having suddenly become embroiled in cryptocurrency transactions, you would have made it clear to HUOBI that you don't do this. You didn't, did you?
I did to Christian. Christian supposed to rely, I know this is what exactly happened officially, and I remember that you have all the evidences on that. I have told Christian to stop.
You say in your first witness statement that you were furious about the test run.
Yes.
But I would suggest to you that at the most you sound cross in your last email of the 27th of January. At the most you sound annoyed. And you're simply annoyed about the lack of fees and that TABARAK might get rumbled by the bank for doing a crypto-related transaction. You certainly weren't furious, were you?
It's not about furious. So furious means I'm angry and dissatisfied with what's happening. Furious means I'm going to scream this. This is what my understanding in English. Furious
furious.
Yeah, let him finish first, please, then come back. Go on, Mr. Ahmadi.
Counsel, English is not my first language. When I meant furious, maybe I'm very angry, very upset. I don't know what's the difference between an English language furious and other thing. Maybe furious, I know, is like getting really very, very angry. I was not very happy at all from what was going on. That's why I have to interfere on that day, and exactly after that, I stopped everything. I stopped, even I have, it's not that I am the one who informed HUOBI, but I informed Christian, and Christian officially informed HUOBI about my last decision on this.
So on your version of events, by this stage, and even before discovering you say about the test transactions, you'd told Christian that we can't get involved in cryptocurrencies. And in fact, you told him more than once. Yes?
I told him not even more than once. He knows anyway. I don't need even to say to him. He knows very well.
And yet you have an employee here who then, on your case, ignores what he's been told by you and goes ahead with a crypto-related transaction. And yet, at that stage, you didn't dismiss Mr. Thurner.
That doesn't lead to dismiss a client, even or an employee. I'm sorry. An employee, a human being is a human being. They make a mistake. So maybe actually it's a good time for me to educate him more and give him the awareness of the dangers of doing this business, why should I dismiss him? I mean, there's nothing that I can dismiss him on that. I don't think so. Anybody will do that, not even me. They might tell him, listen, this might be verbal warning, yes, don't do it again, otherwise I'll take action against you, which is, yes, this is a normal thing, but dismiss, I think this is way beyond what you are thinking, Council.
Now, had you been so angry or dissatisfied as you say you were, and if you really didn't want the cryptocurrency related transactions or activities, if you didn't want TABARAK to be involved in those, then what you wouldn't have done would be to allow meetings between HUOBI, the buyer, and TABARAK to occur at TABARAK's offices, would you?
Could you speak up again? Sorry, we didn't catch the first part of your answer, Dr. Ahmadi.
No, but I said she said prevent meetings. Can you specify the date of meetings?
Okay, well, for example, not least, it's improbable that you would have allowed the Bitcoin transaction to proceed on the 3rd of February. And you knew exactly what was going on that day, didn't you? You knew that transaction was going ahead.
Yes, and knew that. You know why? Because we already have terminated all our relationship with HUOBI on 28th of January. No more relationship with HUOBI. So the premises, the 3rd of February, it is not that the transaction happened with the invitation of TABARAK. In fact, they asked us if we can use your venue to conduct that transaction. And I was to conduct their own transaction without the involvement of TABARAK, without the advising of TABARAK, and Mr. Christian came and asked me. I said, no problem. If they want to use it as they are your friends, we will be meeting outside, we have personal relationship. However, already we know HUOBI is not a client. We know Morrisov is not a client. We know that, and then your senior staff come and ask for a favor. Can we use the venue as a mutual venue to use this one? So,
okay.
Why not? Have an agreement with Christian by me providing the venue that we are not involved at all on this.
Now we do know that Mr. Thurner WhatsApped HUOBI the next day, namely on the 28th of January. And we can go to that at 9416. And right at the top of that page, sorry, I'll just give you a moment to find it.
No, I'm already in the page a long time.
Oh, good. And he does indeed, Mr. Thurner does indeed WhatsApp HUOBI. I have to apologise in the name of TABARAK. Dr. Ahmadi is complaining regarding account opening fees. So, now of note in that message, he only says that you are complaining about account opening fees, not about anything else. Because you weren't bothered about the fact that HUOBI was and TABARAK were to be carrying out crypto-related business, were you?
No, it's not that. See, I am bothered about two things. First of all, they have not completed an onboarding to be a full client. Didn't pay the fees, didn't comply with the full, didn't provide us with the full documentation required. Yes, I'm definitely concerned of that, because all this time he was meeting and all this. So we should have brought them on board being actual client, because we have procedure on that. Besides that, of course, how could he provide services? I'm talking about before 3rd of February. He knows very well, I'm annoyed that we cannot provide services to any individual corporate without becoming client. That is my most annoyed of.
Now, by this stage, you knew, because Mr. Thurner would have told you that HUOBI had provided all the requested due diligence documents. I don't expect you to agree to that, but I'm putting our case. So really, the claimant's case is that by that stage, it's simply the only open questions were the account opening fee and any fees for transactions.
Yeah, account opening fee, any fee for transaction as per the scope of our business. Any success fee on any transaction that we can provide to the clients or to the proposed clients. So it means like what we do now at this moment. ABC come and open account with us. They pay account onboarding, account fee, non-refundable 25. They fulfill the requirements of the due diligence. Their compliance good go ahead. They are officially client and they write us letter of intent. TABARAK, we would like to invest on this. Can you find us a medium-term note? So we find for them, we arrange medium-term note and we make our fee out of the success transaction. This is how we work.
Yeah.
This is what I do with fee, success fee.
Dr. Ahmadi, we then, and this is for context, we come to 2 meetings at TABARAK's offices. Firstly, on the 29th of January, we heard that Mr. Saxena met Mr. Thurner at TABARAK's offices. There was and Mr. Saxena wanted to smooth things over, and it was agreed that that HUOBI would pay the account opening form. Do you accept that? The account opening fee, sorry.
I'm sure Mr. Turner has already told them my decision. No more business with HUOBI. They are not clients. So Mr. Turner relayed this message officially. That wasn't
a question.
If HUOBI is still insisting they want to be client.
My question.
No, I'm sorry. It's much better, I think, if you just let the witness finish, and then I'm keeping an eye on how things are going. So, would you complete your answer, please, Dr.
Yes,
Ahmadi?
Thank you very much, Your Honor. Having terminated the relationship, closed the relationship between on the 28th of January, and you know, I'm sure you have evidence of that. Close the chapter of TABARAK with HUOBI. Mr. Turner relayed that message to HUOBI. HUOBI, I'm sure they got shocked. Oh my God, why cancel? So they wanted to now come back again to fulfill the requirements of the rest of the requirement that they haven't done, providing the rest of the missing due diligence documents, and plus paying the account opening fee. So still HUOBI is interested to open account with TABARAK. But as far as I'm concerned, after 28th of January, when I decided to close this chapter completely and Mr. Turner informed them, there was no any communication after that, except on the 3rd of January, that I am involved in.
Now, later that day, Mr. Al-Ali and Mr. Thurner agreed that TABARAK's account opening fee would be paid out of the transaction proceeds. And the reason for that was that while HUOBI had no objection and in fact had started taking steps to pay the transaction fee, it wasn't the account opening fee. It wasn't possible to make the payment in time for the planned execution of the transaction the next day.
I was not aware of that.
Now, on the 30th of January, you will have been aware at the time that there was a meeting at TABARAK's offices between Mr. Thurner and HUOBI, and in particular from HUOBI, Mr. Saxena and Mr. Nahak. Yes?
I don't remember that. I was not involved. I was not being informed even.
And the purpose of that meeting was to finally execute the first tranche of the Bitcoin transaction. But the buyer turned up too late. They couldn't get the deal done that day. But the real point I'm making here is that the meeting was at TABARAK's offices. So Mr. Thurner was not trying to hide anything from TABARAK.
Mr. As I told, after the council, please remember, as I mentioned, after 28th of January, I never heard anything about HUOBI with TABARAK. I never know that there is a meeting going on between Christian Turner, and I'm not always in the office. Anyway, we can have meetings with HUOBI, with different people. At the end of the day, from my point of view, that no relationship with HUOBI exists at all. I close this chapter. Having said that, they came and meeting Christian Turner in the office, they meeting that. I don't know, I'm not aware of that. Mr. Christian Turner, he meets 10 maybe a lot of clients every day in the office. I'm not like every client he meets, he tells me, I mean, not necessarily. But as far as I know, HUOBI case is closed from our side, from TABARAK, as per TABARAK and Board.
Thank you, Dr. Ahmadi. I understand we're overdue for the transcribers break.
I'm very sorry. I'm very sorry. Please, during the rest of the day, please draw to my attention that we've reached a point when there should be a break. I should have encouraged you to do that at the beginning of the proceeding today. We will break immediately. I think this is the half-hour break. That's right, isn't it?
Yes, yes.
Good. So we shall resume at 1/4 the hour. Thank you very much.
Yes, thank you very much.
Resume.
I'm available.
Good, thank you. Is Ms. Ahmad on deck?
Yes, I'm here. Good afternoon.
Good. Yes, thank you. Mr. Matu?
We are all here as well.
You're all there, fine.
Yeah.
Well, do continue, please, Ms. Stewart.
Thank you. Papers in order. Right, so now we come to the 3rd of February. Now, you say in your witness statement of the 12th of October that you were aware that representatives of HUOBI were attending TABARAK's offices on that date and for the purpose of entering a transaction for the sale of Bitcoin to Mr. Morozov, yes?
Yes, that's what I was told, yes.
So Mr. Al-Ali, Mr. Saxena and Mr. Nahak of HUOBI arrived at your office sometime after 10, and you went to meet them together with Mr. Thurner and Miss Zavialova. Pleasantries were exchanged, and then either Mr. Al-Ali or Mr. Saxena said something along the lines of, "We're pleased to be a client of HUOBI's," and you replied, "Well, you're not a client because you haven't paid the account opening fee." Their response, do you agree that that happened? I'm not expecting you to agree, but I'm putting it to you.
I don't agree because you already asked me about this earlier. So I don't agree with that.
And their response was that the account opening fee would be deducted from the proceeds of the transaction, and also the commission to TABARAK on the transaction would be deducted from those proceeds. And that they pointed out that this had already been agreed with Mr. Thurner. That happened, didn't it?
No, it didn't happen, of course. You are repeating the same question in the beginning of the questioning, actually. It's the same thing. You asked me already this question. I think I believe I answered.
Council who asked you.
You
Actually.
repeating it like on purpose, like, or you forgot that you asked me? Sorry, just my.
Well, I think, in fact, I think it, excuse me, I think it was TABARAK's council that took you to.
Okay, I think about it.
Passages. Well, that's kind of right. Let's get on then.
Okay, sorry, Your Honor.
And after HUOBI said that, you didn't say anything in response. You just left the room soon afterwards and allowed Mr. Thurner to get on with the transaction. You allowed the transaction to proceed in TABARAK's offices, correct?
No, that's incorrect.
Sorry, you didn't allow the transaction.
First of all, you asked me about if I agree the account opening fee to be deducted from the transaction. I said this didn't happen, and then you asked me if Mr. Saxena discussed this to me, and I said to them, no, you cannot. You need to open account opening fee first. I never mentioned that. I never discussed any of this point during that day of the meeting.
No, I think we've got that. I think Mr. Stewart was intending to go on now to a fresh matter.
Okay, no problem. Okay. I wanted to explain that on the 3rd of February, neither the buyer was client, neither the seller was client. As a gesture from TABARAK, we provided them a neutral venue to conduct their own transaction within their own control. That's been agreed between me and Christian, and I think Christian has already expressed that to them very clearly.
Now, I'm aware you don't agree, but we would say that Mr. Thurner had already told you that he'd agreed with HUOBI that the account opening fee would be paid from the transaction proceeds. Alternative, maybe you were just trying it on at the meeting. Alternatively, you thought at the meeting, well, in your mind, well, they're all here. TABARAK's going to get the account opening fee. TABARAK will get a commission on top. And you thought, well, there are lots of these transactions that are due to happen, so we can make lots more money out of this. And you knew that some of your clients were likely to be interested in investing in crypto assets, and that in turn could lead to further generation of income for TABARAK due to the relationship with HUOBI.
Disagree with all what you said, Council.
Yeah. Because of course, all of this is what HUOBI and Mr. Thurner had been discussing, and this is what Mr. Thurner had related to you as well.
Mr. Thurner will not discuss something that he did not agree with me. This is one thing. Definitely, that is a statement of the claimants. This is their own statement. But I am sure Mr. Thurner will not say something that I did not mention or even agree with him.
So you thought, well, let's get on with it. Let's get on with the transaction. And it's true, isn't it, that at no stage did you ask Mr. Al-Ali, Mr. Saxena or Mr. Nahak, anyone from HUOBI, to leave the TABARAK offices? Yes or no answer?
Of course not.
Now,
I invited them to come and use my meeting room as a gesture. Why should I kick them out? Anyway, there was no topic for me to discuss if they're going to pay account opening fee. HUOBI becoming client is a closed subject completely.
So I understand your position. You say that the conversation between you and HUOBI about them being a client and the account opening fee being paid out of transaction proceeds didn't happen. We say it did, but let's just assume it didn't. You walked out of the room saying something like, I wish you all the best. Yes?
Yes, something like that. We welcome everybody. I said, okay, have a good day.
And the fact remains that you knew, at the very least from the emails that I've taken you to, that HUOBI was going to sell Bitcoin to the buyer for fiat currency. You knew that?
During that day,
Yeah.
February, yes, they were conducting their buying and sell transaction. As I said, I keep repeating again, we got nothing to do with it. We are not in control. We are not providing any advisor or any arrangements. The only thing we provided is the venue. And that's it. Mr. Turner expressed this to them when I came to the...
But you also knew that from the emails that you'd been copied into, that the process had to be structured so that the buyer wouldn't receive the Bitcoin until payment was assured.
That's from the communication. Yeah. That is logic anyway. The buyer, how you as a cryptocurrency expert, HUOBI, on which basis you transfer coin to a buyer without making sure that the money is in your account or in one of your company's account? I mean, that is...
And you knew that this was therefore why TABARAK, a DIFC licensed and regulated investment bank, had to be involved in the transaction, because otherwise it couldn't go ahead.
No, but we are not involved in that transaction. As I mentioned, counsel, I mean, you keep repeating everything. Our only job on that day was to give them a neutral venue to conduct the transaction.
You were aware from the emails.
Please, can I finish, please? And I keep repeating. You keep repeating the question, and I'm keeping repeating the answer, the same thing. Our role was only to provide a neutral venue for people that they tried to be client with us, that they failed, and we have no relationship with them. Senior staff of me said, can we please provide them a venue? I said, yeah, provide it. We are not involved. We don't oversee the transaction. We don't provide any advisors, anything. That's been agreed, and the buyer and seller knows that very well.
So you also knew by that stage that Mr. Thurner, in his role as Director of Investment, had sought agreement from HUOBI and the buyer on different proposals, different proposed mechanisms to meet their objectives.
Can you please rephrase your question more, because I didn't get it, if you don't mind, sorry.
So you also knew by the 3rd of February, you knew from emails that Mr. Thurner had sought agreement from HUOBI and the buyer on different potential ways in which the transaction could be conducted.
There was no any agreement, neither between a Christian... No, there was no any agreement. Not between Christian and the other parties, or between TABARAK or the other parties.
My question was,
Mr. I'm sorry. It's much better if we let the witness finish. So please, do go on.
Yeah,
Dr. Ahmadi.
Yes, thank you, Your Honor. I mean, I tried to explain to the respective counsel again and again and again, because she kept repeating the same question, and I'm willing to hear it and answer it, but it's getting too long, like the same question. As I said,
well, I'm in charge, and I try and strike the right balance here. So, if you could just finish your response to the question. You were emphasizing that as far as you were concerned, what was happening was simply the use of the room, and what was to be done would not involve TABARAK in any way. It would be a matter between HUOBI and the buyers to carry out their transaction. That's your response, as I understand it.
That's precisely, and that's what I'm trying to explain to the Honourable Counsel.
Well, I think I've got that part of your evidence, as I've got all the rest of your evidence.
I mean,
Now,
I'm sorry, Your Honor, I understood your question very clearly and I answered. I wish I understand her question clear. I will answer. I'm here to answer every single question.
I quite accept that. I quite accept that.
And you knew from the emails that that I took you to earlier that it was proposed that a TABARAK bank account was going to be involved in the transaction.
There was no email after that. I don't know. See, there is no way that they can use TABARAK bank account after 28th of January. There is no deal. No one of them is client of TABARAK. No one of them is client of TABARAK. So there is no email exchange, or I've been copied from 28th till 3rd of February. Whatever the agreement came procedure, it would have been between the buyer and the seller. They are using TABARAK bin only.
And you knew that the proposals in the emails from Mr. Thurner to HUOBI that you'd been copied in on involved a TABARAK Trezor wallet, correct?
That was the previous years before. That's, as I said, that was the previous before we terminate relation with HUOBI. But that does not mean they will still carry out with the same procedure on 3rd of February, because we are not involved, basically. So they should have, I am sure they met before that, the buyer and the seller, they agreed on their own procedure. That is 100% this is what happened.
So you also knew that TABARAK had confirmed that the buyer had placed verified funds with TABARAK at a correspondent bank in Europe, yes?
Means the seller or the buyer put money on TABARAK's corresponding bank in Europe. First of all, we don't have any account in Europe. This is something. All our accounts only in Dubai bank, UAE banks.
So you're saying now that you don't have a correspondent bank?
We don't have corresponding bank account outside UAE. Our accounts only in UAE banks only.
So in the email,
if our corresponding bank has account with the European bank, this is a different story. I'm sure they have all banks for exchanging, transfer, remittances. They use their corresponding bank, but we don't know who are their corresponding. We never interfere on our bankers' corresponding bank, or we concern is our account with the local bank.
Next question.
And also you'd verified that the buyer and a partner of the buyer had funds in the UAE with 3 major banks of close to 50 million dirham.
No, it's not true. Nobody verified that. TABARAK has never verified that the client has account in corresponding bank, as you said, in Europe, or even bank in UAE.
And you were aware that
procedure that they agreed on when they were copying me before we terminate the relationship with HUOBI. We are trying to bring it as if they are applying same procedure on that day, on the 3rd of February, which is not true, Council. We got nothing to do on 3rd of February. It was not. So whatever agreed between buyer and seller is their thing.
So you were aware that test transactions had been carried out, one of which you were clearly aware because you've said had involved Bitcoin.
When was that? Can you specify that?
Well, we looked at it before we had the break. Do you remember?
Yes, I'm just trying to confirm her if she is referring to the last previous transaction that I was aware of that. Yes, that is, but that did not mention the cryptocurrency transaction.
And going back to the fundamental point that you knew that HUOBI and the buyer were meeting at TABARAK offices to carry out this Bitcoin transaction, that's not in dispute. And you knew, obviously, that Mr. Thurner and Ms. Saviolova were attending that meeting, correct?
Yes, I know they were attending the meeting, yes.
Therefore, I suggest to you that you knew that TABARAK's role can only have been to provide services to HUOBI and to ensure that the buyer, in order to ensure that the buyer couldn't obtain the Bitcoin until payment had been received from the buyer, and that this was done by TABARAK.
The date of the transaction you're referring?
Yeah. Until transaction on the 3rd.
No, absolutely not. It's all your own assumption, unfortunately.
Okay.
And therefore,
Go on, Mr.
it ought to have been obvious to you that TABARAK offices were not simply being used as a neutral venue, and your assertion in that respect is obviously nonsense.
No, there's nothing of nonsense. I told the truth and nothing but the truth. Our office is being used as a discharge for a couple of hours as per the request of one of my senior staff. They don't have anywhere else to conduct the transaction, provided condition 1, 2, as I specified before. Nothing to do with us. We are not involved with that. They said yes. He already informed them. I said, okay, no problem. As a discharge, they can use our office. Anything beside what you are mentioning is all incorrect.
Now, the buyer and seller could have gone anywhere to complete the transaction. There was no need whatsoever for it to be carried out in TABARAK's offices if TABARAK wasn't involved, was there?
Yeah, that's why I'm surprised why they did not do it in Dubai Mall, as they've been meeting on a regular basis. Because maybe they wanted somewhere to be quiet, no disturbance.
Well, if they wanted that, Dr. Ahmadi, they could have just rented a room for half a day in the DIFC or anywhere in the UAE, and that would have cost a tiny fraction of what the commission amount actually was, the commission amount being in excess of $7,000.
Well, this one you can ask HUOBI and the buyer and the seller why they did not. Maybe they are too tight with their money, they don't want to spend. They said, okay, once we are getting somewhere for free, why not we use the office? So you should refer this question to the buyer and the seller.
So after meeting with HUOBI at the outset, you left Mr. Thurner in the meeting room to complete the transaction. As to what happened in that room, I'll leave that to my cross-examination of Mr. Thurner. Now, sometime later on the 3rd of February, sometime after 1 p.m. Dubai time, Mr. Al-Ali was on his way out of the TABARAK offices when you met him and you invited him into your room, didn't you?
You mean it during after the meeting exactly?
When he was on his way out, Mr. Al-Ali left.
When you mean after they conducted their transaction?
And he bumped and you met him.
When
and you
they
invited him to a room.
Finished the transaction, you mean?
Sorry.
Same day of when they finished the transaction? No, I did not invite anybody to my office.
And you said to Mr. Al-Ali words to the effect that you were happy that at last TABARAK and HUOBI had finally managed to execute the transaction, correct?
Not correct. I tell you what happened. Can I, Your Honor?
Yes, that's what we want to hear from you. What do you say?
Yes, after they finished the transaction, supposed to successful transaction, all of them came to my office. They walked to my office without any prior appointment or anything. They came to me, they were all happy, big smiles and everything. They said, oh, we finally, they came. Crystal Turner, the buyer and the seller, Mr. Sultan is there. And I stood for them. I stood, and instead of sitting, doesn't like polite, I stood to them next to my desk. They were very happy. They conducted the transaction. I said, oh, I'm happy for you. And that's it, nothing more than that, except what happened after that, which I'm sure you don't.
So at least we can agree that at some point, Mr. Al-Ali, Mr. Thurner and the buyer were all in your room. Is that correct?
Mr. Ali and the buyer and the seller, they came to my room, yes. But they came to my room for a different purpose.
And at this point, and you'd also said to Mr. Al-Ali something along the lines of, the buyer was an old customer of TABARAK's who you dealt with on many occasions.
Oh, that's not true.
And therefore you were really happy, basically you were conveying that you were very happy that this had gone ahead finally.
Counsel, that's incorrect. Absolutely incorrect.
I hear
How
your
could
answer. I
say
your answer.
client, and none of them was a client of Tabarak? Cannot be. It's insane. I say to somebody, oh, he's a client, and he's not a client. This is impossible. This is my responsibility. It means I'm lying. None of them was client of Tabarak.
Okay.
Now,
Go on, Mr. Chair.
and then before your very eyes, you allowed the Trezor device to be locked in the safe in your own room.
Let me phrase this, not I allowed. They came all to me to my office after they smiled on their faces, and they, all of them, I'm sure they have agreed, they came to me and said, Dr. Ahmadi, can you keep this in a safe, in your safe, all of them, the buyer and the seller with Christian Turner. Can you put this USB key, whatever it is, in your safe? I said, no problem, with my pleasure, I'll put it for you there for a few hours. They said, for a few hours. I said, okay, I will put it. They even asked me if anybody has access to this safe. I said, nobody has access to this except me. I'm the only one who has a combination. This is where I put the USB key, and I put it in my safe and locked it.
Now, you would accept, would you, that whoever had access to the physical Trezor device had access to the Bitcoin?
I don't know about that, to be honest with you. I don't know how it works. The mechanism of how it works, I really don't know.
And the purpose of locking the Trezor in your safe, in Tabarak's safe, was to keep the Bitcoin safe until the buyer had paid for them.
I have no idea. They didn't even tell me what's inside the Bitcoin. All they told me, USB key, can you please, doctor, put it in your safe? I said, okay, I'll put it, no problem.
And as soon as payment hit Tabarak's account, then Tabarak would transfer the Bitcoin to the buyer, or the buyer could simply take away the device itself.
I didn't get your question, counsel. Can you repeat, please? I didn't understand.
So the way the transaction was supposed to work was that payment for the Bitcoin was supposed to flow into Tabarak's account.
I don't know what they agreed on the meeting room. I was not there, present in the meeting room.
The short point being is that because the Trezor was locked in Tabarak's safe, Tabarak was acting as a safekeeper, a custodian of the Bitcoin. And the point is that if Tabarak had in fact kept the Bitcoin safe, from HUOBI's perspective, it didn't matter whether or not the buyer made the payment for the Bitcoin. Of course, they would have preferred it if the payment was made, but it didn't actually matter because if the payment wasn't made, Tabarak would simply transfer the Bitcoin back to HUOBI, wouldn't they?
Can I ask you a question? How come the HUOBI, they transfer the Bitcoin without having their money to their account? How come? This is something unbelievable. An expert company like HUOBI, they transfer, as per their policy, first they see the money, then they transfer the coin. And then the experts of HUOBI was there, the CEO and the expertise. I'm sure they knew what they were doing during the meeting, and I'm sure they knew why they asked me to keep the Trezor in safe place. What they agreed in the meeting room, I have no idea. All of a sudden they came to my room, keep it there. That's it.
Now, Ms. Stewart, it may help if I tell you that this witness can't really give direct evidence about what the legal implications were
No, I
of
understand.
them agreeing that the wallet goes into his safe. He's accepted that it went into his safe. He's explained from his point of view how that came about. And then I think it's a matter of legal, submission as to what, if any, the legal consequences of that are, okay? So perhaps we could move on a little bit.
So the short point, I was just about to, the short point is that had this Bitcoin transaction proceeded as had been anticipated, TABARAK would have happily taken the account opening fee and the commission. They would have pocketed that, a sum of over 32,000 US, wouldn't they?
Repeat again the question. I said no. We got that transaction on that day got nothing to do with account opening fee. We did not discuss of bringing back HUOBI as a client paying account opening fee from what they earn from the transaction. That's absolutely not been discussed or even brought up to my attention.
Now, there's not a shred of evidence that any of this was carried out by Mr. Thurner other than in furtherance of TABARAK's business, is there?
I'm sorry, can you repeat again?
Mr. Thurner carried out all of these activities for the purpose of progressing TABARAK's business, didn't he?
But which activities you are referring to?
The transaction, the test transactions, the involvement in the transactions, all of this.
First of all, as I said, Mr. Turner knows very well how we can make money, which way we can make money. It all has to be legitimate, very much, and he's aware of that. Had Mr. Turner thought about making on that day of transaction, Your Honor, there was no discussion of that. We are charging them on the meeting using our facilities or even making money out of the transaction. We just give them an access to an office to use it. Whatever Mr. Turner was thinking, then I cannot go into his brain and see what he was thinking. But Mr. Turner is a senior staff. He knows his responsibilities. He knows what he's doing. Maybe he tried to help other parties to bring them together to do a business transaction. Maybe he did as a goodwill, because he knows damn well I was not going to bring back HUOBI to be a client after all what happened. After 28th of January, I said, no more, HUOBI will never be client, even if they say we're going to pay account opening fee, because now I had clear picture what HUOBI was aiming to use TABARAK for. They wanted to use it for their own. That's why I closed it completely.
Well, I understand that. Now, what's being put to you is this, that both before a point was reached when on your evidence, you told Mr. Turner, this cannot progress anymore for the reasons that you have given. Up to that point, consider Mr. Thurner's dealings with the HUOBI and the buyer, and then also consider what went on the 3rd of February in the room. Counsel is putting to you that at all these stages, in respect of all these activities, vis-a-vis HUOBI and the buyer, Mr. Turner was acting as an employee of TABARAK. Do you agree or not?
But Mr. Turner was employee of TABARAK, but was he following the instruction of TABARAK? That is the question. The instruction of TABARAK to Mr. Turner, we don't accept any cryptocurrency transactions.
I'd just like to go back to one. You said that, as I recall, that TABARAK doesn't have any correspondent banking relationships. Is that correct?
Yes, it is correct. Yes. As I said, our relationship is only with local banks, UAE local banks.
Okay. Can I take you to page 369, please?
Is that 8369 or?
Yes,
or is
I
it-
apologize. Yes.
Yes, 8369. Okay.
Yes.
And I think you agreed before that these account details are TABARAK's account details.
Of Tabarak with a Noor Bank. Yes, is our details. Is our account details in Noor Bank, which is a local Dubai bank.
Yeah. And a correspondent bank here on 369 is listed as Citibank New York, correct?
Yeah, that is corresponding bank of Noor Bank, not our account. We don't deal with corresponding with our bankers corresponding bank. Only for remittances, Noor banks give interaction. If anybody wants to transfer money in US dollar, use this. But that Noor Bank account in Citibank is Noor Bank account, not Tabarak account.
And then going to page 370.
It's the same thing as in the Euro account details.
Yeah, Standard Chartered, yeah?
That is the Noor Bank account in Standard Chartered, not the Tabarak Bank account.
Thank you. Now, you discover that it's discovered that the Bitcoin has been stolen. Now, after the theft, you had a conversation with Mr. Al-Ali when you said that you'd try to recover the sale amount, which was close to $3 million from the buyer, and that you would push the buyer to pay as the buyer was your customer.
Absolutely incorrect.
Now, you said earlier today that you don't even have the contact details of Mr. Al-Ali, but that's not right, is it? If we go to 9450,
Yeah. Yeah. Yes,
This is-
I can see that. Yeah.
this is a WhatsApp exchange between you and Mr. Al-Ali, isn't it?
That's correct. Yes, that's correct. And this WhatsApp, the only time that we exchanged, me and Mr. Ali's contact details on that incident when the police officer were interrogating member of the team or the people who were there. Therefore, Mr. Ali, he asked me, Doctor, he was literally begging me, your counsel, please, doctor, interfere, try to find a solution, try to find. I said, how could anyway? We exchanged numbers, I said, let's talk tomorrow. That, for me, what I suggested in the front of Saxena, if allow me to explain that, Your Honor, if it is okay.
Yes.
If I want to answer the counsel's, she said about my relationship communication with Mr. Al-Ali. Mr. Al-Ali's relation with me communication started only on the 3rd of February, and that's it. We exchanged telephone numbers. We said, okay. He said, please, doctor, please help me. This, I said, okay, let me see that now the guys are still under interrogation. Let's Christian Turner come out from the custody of the police. I will try to arrange a meeting between all parties, sit and discuss about the incident. I did not mention that Tabarak is responsible for that. Tabarak is, I said as a gesture as well. In fact, he was literally begging me that, please, doctor, please find a solution, please help me. That is exactly, I swore on the Holy Quran, that is what happened. That is the only time that we exchanged telephone numbers between me and Mr. Al-Ali.
Now, you also had a conversation with Mr. Al-Ali and Mr. Devar on the 9th of February, didn't you?
Yes, exactly. That was the plan. The plan is, as I said, as I mentioned earlier, I informed Mr. Al-Ali, I said, okay, I will do whatever I could to come and try maybe to help a bit on this way on. I will try to arrange a meeting between all parties who were involved in that transaction. All parties, I mean the buyer, the seller, turn up, and I told him I will attend. And he told me, can you please speak to my partner in London about that? I said, no problem, more than happy. So I don't know which day, 9th of February, as you said, I spoke to somebody in London. I don't remember the name that time, but now I can remember. It's the same request came from Mr. Ali on 3rd of February to me. Same came from the one in London, Mr. Devar. Please, doctor, please help us with finding a solution. That is where I give him the same plan of mine. I said, listen, I'm just trying to organize a meeting. I will attend to that meeting, and all of us should attend the meeting and see how we can come to a solution. Meeting, as I mentioned earlier, it will be Mr. Turner, buyer, seller, and I will attend the meeting, I said, in order maybe we can come up with a solution. That is the communication and the WhatsApp communication between me and Mr. Al-Ali.
Thank you. Now, Mr. Devar and Mr. Al-Ali in that conversation made it clear that they expected TABARAK to pay HUOBI for the losses that HUOBI had suffered as a result of the theft, didn't they?
I don't know whether they exchanged that. They exchanged that email with WhatsApp. I have no idea.
This was during the meeting on the 9th of February.
First of all, Council, that was not a meeting. It was a conference call, just to put you in.
Now Zoom world.
Conference call. I never met the gentleman in London, Mr. Devar, and then Mr. Al-Ali. There was no way that we discussed that TABARAK will pay HUOBI about this, what happened, because TABARAK has got nothing to do with this transaction. TABARAK is not involved with the loss of the 300 Bitcoin of HUOBI or their whoever they borrowed the coin from. TABARAK, same as the gesture giving the venue for transaction. TABARAK, as me, I said I will try to arrange a meeting after the guys they come out from the police custody, and we sit and try to find a solution. That is what my conversation with Mr. Devar was as well.
Now you received.
Now wait a moment, please. I'm sorry. What's put to you is that at the meeting, it turns out to have been a teleconference. What's put to you is that those representing HUOBI told you that they held TABARAK responsible for what had happened, and they were going to look to TABARAK for compensation for what had happened. Now, is that true or not? Was that demand made to you by the representatives of HUOBI during this teleconference?
No, Your Honor, it's not true. It's never been brought to my attention.
Never brought up. I see. Thank you.
They are asking me for help. How could they ask me to pay? Of course, if they tell me to pay, I said, why should I pay you? But it never came to my attention.
It never came up. That's all right. Yes. Thank you.
And then you will have received a letter before action, so a letter from HUOBI's solicitors, which was dated the 13th of February.
Yeah, we received the letter, but actually no, the first thing, we didn't receive a letter. That is HUOBI's claim in front of the ISC court. Let's talk about after that, after I volunteered to help Mr. Al-Ali and HUOBI, talking to them. But unfortunately, the meeting has not been materialized for some reason. Mr. Al-Ali went in front of Dubai court and has a case against us in Dubai court, where we defended it.
I'm sorry, Doctor. What Council's moved on to is a letter from the lawyers acting for HUOBI, and she's suggesting that in that letter. Could you give me the date again, Mr. The letter?
13th of February.
Well, a letter of the 13th of February came from lawyers acting for HUOBI, stating that HUOBI was going to hold TABARAK responsible for the missing Bitcoin. Now, did you receive that letter?
Yes, we did receive that letter.
Right.
We engaged lawyers as well after that.
Yeah.
Now, So this is a fairly serious letter asking you to seeking compensation for significant amounts. By that stage, you knew that a very serious theft had taken place, which involved TABARAK employees. Not that I'm saying that they stole the monies, but they were involved in the activities surrounding the transaction and the subsequent theft. Correct? You knew that because you knew that they were at TABARAK's offices on the 3rd of February.
I didn't understand exactly what you were trying to ask me. Can you ask me a question?
Right. You knew that Mr. Thurner and Ms. Zavialova were closely involved with events on the 3rd of February, which ultimately led to the theft of the Bitcoin. Correct?
Yes, that's correct.
And by this stage, you'd received a solicitor's letter seeking compensation from TABARAK for a sizable amount of money. Correct?
I received a letter from a lawyer, yes, by email.
Now, despite all of this, you didn't even suspend Mr. Thurner, did you?
I didn't need to suspend Mr. Turner because, first of all, Mr. Turner is not the one who stole the coins. And secondly, neither TABARAK. And beside that, Mr. Turner already submitted his resignation on the 19th of February.
Well, that's rather the point. It was Mr. Thurner who submitted his resignation by way of letter dated the 19th of February. It wasn't that TABARAK suspended or even fired Mr. Thurner.
I see, as I said, I knew very well Mr. Turner has got nothing to do with the disappearing of the 300 Bitcoin. Secondly, as I mentioned earlier, if there was something that I know Mr. Turner is really involved in that disappearing of the Bitcoin, I would have taken action immediately. However, once the incident happened, we have done internally with our admin, we did an internal investigation, and we have got reports on that, of the whole incident, what happened on that day. Just for this is a standard thing. But then, as I said before, you asked me why I don't terminate, why I don't suspend. For what reason I said, unless then the court or the judge or the court convicted Mr. Turner that he is the reason behind, he's the one who stole it, then I can take an action against him. At this moment, I know Mr. Turner and TABARAK are purely innocent on the accusation that HUOBI is claiming.
So you decided he was innocent before actually conducting an investigation, did you?
Yes, I know very well. He has no idea, no involvement on disappearing the 300 coin.
Now, but your case is that in fact, Mr. Thurner went on some grand unauthorized frolic of his own. Yes?
Sorry again.
Well, I think you better avoid phrases like frolic of his own.
So your case is that Mr. Thurner acted in a way that TABARAK had not authorized.
See, on some occasions, Mr. Thurner did not follow the instruction of TABARAK precisely. This is where, if we can recall the whole during the first my witness statement there, where I intervened and I stopped it because I knew that's it. Finish, Mr. Turner, stop it, let's cancel it. But however, there is no need for me to suspend, and there is no need for me because Mr. Turner As anyway, as the chronology of the court, the criminal is clear before he was convicted. Like as in Arabic, I cannot say it in English. Mr. Turner, it's got nothing to do with disappearing of the coin. I don't have the right to suspend him, or there is no reason for me to suspend him. In fact, Mr. Turner was trying to help both parties to interfere, buyer and seller, to try to find a solution. What happened? He was surprised as well as like us where the coins went. And different occasion, I was managing banks for many years. Different occasions, sometimes employees, they don't listen to the instruction of the bosses, but doesn't mean if they don't listen that you need to terminate them immediately. No, you have to talk to them and educate them. So you need to do this and do that in future. This is exactly what I said, what I did to Mr. Turner when I terminated the relationship between us and HUOBI on 28. I said, please do not involve yourself in any cryptocurrency as long as you and Tabarak is involved. And he understood that.
Now, the reason you didn't suspend Mr. Turner pending conclusion of an investigation, for example, and the reason you didn't fire Mr. Turner is because you knew that what he was doing was authorized by Tabarak, didn't you?
No, I did not. I will not put it in the way that authorized by Tabarak. He was not authorized by Tabarak to conduct a cryptocurrency transaction prior to 3rd of February. 3rd of February is a different story now because we are just providing a venue. Mr. Turner knew very well we don't do cryptocurrencies.
Now, you say that you wouldn't do cryptocurrencies because you're not allowed to. Correct?
Yeah. We are not permitted.
You weren't allowed to at the time.
Not allowed. We are not permitted. It's not our license does not permit us to do cryptocurrency. So full stop. So why should we do it? Why should I jeopardize my license? Okay, as I said, I don't want to bring up again the same conversation that we don't listen. We just close the doors and anybody tell us about it. We listen to people. We listen like anybody else, any other firm as well. If there is something proposed, they will listen. We can do that. That's
basically your case.
We are an organization. We are not a government entity. We are a commercial organization. We see. Pardon?
Now, on your case, at the very least, the 2 Bitcoin transaction that occurred earlier in January 2020, on your case, that would be in breach of your regulatory obligations, correct?
I don't call it a breach. We are not authorized. We are not authorized to do it. So maybe Mr. Turner was trying to also do it to test, as I said, to see how compatible our banking system is.
So a breach of. Let him finish, please. Right. Okay.
So one of the transactions involved 2 Bitcoins, which you said Tabarak was not allowed to do, and yet there's no evidence whatsoever of you reporting about that incident or the transaction itself on the 3rd to the DFSA, is there?
It is not. It is, first of all, it is a test transaction. Okay. DFSA, even if I go and complain to DFSA, DFSA will ask me, are they a client of yours? No, of course they are not a client of yours. This is exactly what happened. We will explain our position with DFSA. Now you're going back to again same story. As we say, this is test transaction that's been done through Mr. Turner without my authorization or permission. This is where I stepped in later on. I explained to him, we don't do it again, that's it. We cancel everything as we discussed earlier.
Right, I have just one topic remaining. Just going back to the date of the theft, the 3rd of February, at around 4:30, the theft of the Bitcoin was discovered. And then at about 5:30 to 6, the Dubai police arrived. And the police took Mr. Turner and Miss Saviolova into police custody, yes?
Yes.
And they confiscated Mr. Thurner's and Ms. Saviolova's devices, their laptops, mobiles.
Yes, they did, yes.
And Mr. Thurner says that those devices, or his devices, weren't released back to him until around May 2021.
I don't know that, to be honest. By then, I knew, I was informed that the device has been released to them after a couple of months. That's all what I knew, to be honest.
Now, by late afternoon, by late afternoon or early evening of the 3rd of February, you knew that a very serious theft had occurred, yes?
I was, Mr. Turner called me. He said there is some problem disappearing. He didn't say theft or anything the way you want to put it. He said there is some problem here happened. I am calling the police. I said, yeah, immediately call the police. If you think that police needed to be there, call them. So calling the police. And I told him, yes, call the police.
Okay.
Now, in paragraph 71 of your first witness statement, and that's at 679.
679. Yes.
You got that?
Yes, yes, I'm here, yes.
And you say, having heard Mr. Thurner's account of events following his arrest, I sought to discuss the matter with TABARAK's head of HR. Specifically, I wanted to know whether we had grounds to dismiss Mr. Thurner for gross misconduct.
Yes, I'm with you, yes.
Now, so in addition to that, you are clearly very concerned. And in addition to HUOBI saying, look, TABARAK, you need to fix this. We want 300 Bitcoin or the equivalent. And then also, having received the letter around the 13th of February from HUOBI's solicitors, still Mr. Thurner remains in place.
Yes, because we did our own internal investigation. And as I mentioned earlier, Mr. Turner has got nothing to do with the disappearance of the coins. However, maybe there was, yeah, okay.
Now, I'd like you to now turn to 1166.
1166.
Now, this is a document production statement by your HR director. It's dated the 23rd of September, 2021.
Yes, I'm with you. Yes.
Right. Now, are you familiar with the contents of this?
Yes, I am.
Okay, so you know that basically your HR director is saying that Mr. Thurner and Ms. Avialova, they used their personal laptops for work, and they were permitted to do so by TABARAK as long as they allowed TABARAK to install and configure TABARAK's mail application, which was Microsoft Outlook, yes, onto TABARAK's cloud-based storage system. And that was Google Drive, yeah. And then your HR director says that Mr. Thurner's emails would have been stored on TABARAK's Google Cloud Drive until the email address was deleted or the license with Google was removed or lapsed, yes? And you'd agree with those? You'd agree with that?
Yes, so I agree with the statement.
Now we know that Mr. Thurner returned to work at TABARAK following the theft and having been released from custody from the police. Yeah?
Yes.
TABARAK knew, surely, as soon as he returned, that his laptop and phone had been confiscated.
Yes, true.
Of course they did. Now, one of the first things that a responsible CEO would have done, and a CEO who had nothing to hide, would be to ensure that TABARAK's cloud was checked for all Mr. Thurner's and Miss Saviolovas email records. The email records between themselves and email records that were in any other way relevant to the theft. That would have been what should have been carried out in the course of your internal investigation, correct?
I didn't get your question, to be honest, exactly. I don't know what you're asking.
You say you carried out an internal investigation.
Yes.
So surely what that included was checking TABARAK's cloud for any relevant emails involving Mr. Thurner, Miss Saviolova, and anything to do with HUOBI and what had gone wrong.
Yes, definitely yes.
And particularly that would have happened if you were looking into whether you should dismiss Mr. Thurner for gross misconduct, correct?
No, it's not whether to dismiss Mr. Thurner, because we know he didn't do any gross misconduct. It's not natural. Any problem happen in any organization, you arrange internal investigation happen. Either it's been broken something or fighting with something is normal. We assign a team to do investigation. What happened?
Dr. Ahmadi, you didn't actually check TABARAK's cloud account for those emails, did you? And if you did, you certainly didn't preserve those emails, did you?
We had the email of Miss Anastasia and Christian Turner. They were still active. We don't need to check because they were still employee of TABARAK. They're still working with TABARAK. We checked normal email. There was nothing in particular that we were really concerned of. That's normal communication that you have in your bundles.
So you were carrying out an investigation, but you didn't actually preserve any of the emails relating to the transaction.
Preserve means what? What do you mean by preserve?
You didn't store them. You didn't make a further backup of those emails.
We don't need to do any further backup because if any email were there, they will stay there.
Now, TABARAK says in this, your HR director says that it reviewed the backup files saved from TABARAK's Google Cloud Drive insofar as they relate to Mr. Thurner and Miss Saviolova, and they have been unable to locate any emails sent or received as between Mr. Thurner, Miss Saviolova, and HUOBI, correct?
That is after they confiscated their devices you're talking about?
Well, I don't know when these backup files were reviewed, but presumably, but I would expect it was after, yes.
Yeah, maybe. See, which column you are referring to, please?
That's at 1167, paragraph 10.
Yeah, so this says, I further confirm that insofar as such email communication took place, the second defendant and or his assistant.
No, sorry, paragraph 10.
Okay, paragraph 10, okay. Yeah, I mean, talking in particular day, maybe on the 3rd of February. To say provided emails and come down.
So
Can I finish, please, if you don't mind? Still the same thing. The email of Miss Anastasia and Mr. Turner, still they were working even when they left the custody of police.
yes, quite. So
the office, we didn't do it immediately. No.
So now it's suggested that Mr. Thurner and Miss Saviolova double deleted their emails from the Google Cloud Drive. Now, the question is, when could that have occurred? Now, the police arrived very shortly after the theft was discovered, didn't they, on the 3rd?
Well, we know that. We've had evidence about that.
And Mr. Thurner and, as we know, Ms. Saviolova were then taken into custody. Their devices were confiscated. Therefore, I suggest to you that it's not likely that either of them would have had the time to double delete all their records, would they?
Not during their lockup on the station. No, they've been only locked up for 1 day. Maybe they came after that. I don't know. Really, to be honest, I don't have the answer. But definitely, if the HR said that, what she's saying, it's her responsibility to check the emails.
In fact, it's more likely that TABARAK deleted those records, isn't it?
No, incorrect. Definitely no.
That concludes my cross-examination.
All right, thank you. Now, can I just check with our stenographer as to when the next break should be granted? We finish on the hour in London time, 2 o'clock, in Dubai time, 6 o'clock. So I think there's a break due between now and when we finish. And when would the stenographer like to take that break?
Sir, are you saying we're finishing at 2 p.m. in 40 minutes time?
That's right.
For the whole day? Because
Yep.
I'm happy to continue on and not take a break. I'm okay.
No, are you?
Yeah,
Well,
I'll be fine.
Very kind of you. If you are, that will allow us to make progress during 10 minutes when we otherwise wouldn't be. So we're very grateful to you for that. Now,
2 minutes for a restroom break.
Yes, no, we'll have a. We're going to have a. We're going to have a break in a short break anyway, so that we've got to allow the new cross-examining team to be all ready to go. And I think the witness deserves a break. He's had to concentrate very hard. So we're going to take 5 minutes, and the cross-examination on behalf of the second defendant will begin in five minutes' time. Can I hear Mr. Matthew? Will it be you or will it be Mr. Kotick?
It would be me, my lord.
It will be. Very good.
Yeah.
Okay.
Thank you.
Fine. Thank you. 5 minutes. Good. I think our 5 minutes are up. And so, Mr. Matthew, please begin your cross-examination.
Thank you, my lord. Dr. Ahmadi, my name is Salam Matu. I represent second defendant, and I will have some questions for you now. Firstly, Dr. Ahmadi, it's correct that professionally you've been a private investment banker for over 30 years now?
I don't say 30 years. I'm a private banker, yes.
But let's say you've been a private banker for let's say for over 2 decades.
Yeah, maybe. But, I'm not that old.
Sorry, forgive me, Dr. Ahmadi. And you have worked at international banks and in regional GCC banks as a private banker.
Yes, I did. Yes.
And the first time you became had a C-suite management position was when you became CEO of Bank Piguet and C, correct?
Yes. It's not management, CEO position.
CEO.
Yes, with private.
Okay. And then you founded.
I'm sorry. There's some sort of feedback. I can't hear the answers.
Yes, there's an echo coming from somewhere.
The echo. Is my voice clear?
Well, it is now, certainly. Well, shall we
I
go on? And
we
yes,
need people,
yes.
everyone who's not speaking, if they could mute. So we just
Yes.
have the two active ones, and then the feedback
Yes.
might stop.
Right. Right. Let's do that, everybody who isn't actually. So really, it's just the witness and Mr. Matu, and occasionally myself, who will be unmuted. Yes, next question, Mr. Matu.
You founded Global Investment Limited Dubai in December 2010, correct? And you were the CEO as well.
Yes.
And then you sold it 3 years later, correct?
2013. Yes.
And then you founded the TABARAK Investment Bank Limited, which was officially launched in 2014. That's correct, right?
Yes, that's correct.
And you changed the name of the bank to TABARAK Investment Capital Limited in November 2015.
Yes, that's correct.
And given your vast experience as a private banker, as a CEO, as a person who has run companies, built companies, sold companies, you will agree with me that you must be actively involved in your work and business. Whatever you do at TABARAK, you would have a good visibility of it, correct?
Yes, that's correct.
And in 2019 and 2020, TABARAK was a very small organization. You would agree with that, right?
TABARAK is still smaller.
It's even more smaller if I'm correct. Would you agree with that?
We've never been big organization. It's a local firm, I mean, regulator firm, locally established. It's not a branch of any international banks or anything.
Correct. So it's not like Goldman Sachs. It has complex sets of departments. So it's a much more smaller, hands-on bank where everybody knows everyone else, and you know what everybody else is doing. Correct?
That's correct. You can call it as a boutique private firm.
Yes. So if I take you to, please could I take you to 8445?
8445.
This is your website. Let me know when you're there.
Yeah, absolutely. Yes, I'm here.
So you would see that the first page, 8445, is the shareholders. That's Mr. Shahiri and yourself. And then you have the board members, which includes you and Mr. Shahiri and Mr. Carney. And then your management team, which is effectively yourself. And then you have 4 directors, which is Ms. Sumaya Faludi, who is an operations director and head of HR as well, correct?
Yes, that's correct.
And then there's Mr. Abdul Qadir Khan, who's a finance director, and then there's Mr. Aziz Malik, who is director compliance, risk management, and AML. And then there was until 30th June 2020, Mr. Christian Turner. Correct?
Yes, Mr. Turner is there, yes.
So this was, and Ms. Zavidova, you would agree, she was not part of the management. She was just an assistant of Christian, but employed by TABARAK.
Yes, I agree with that. Yes.
Okay. So having seen the company as such, you authorized Mr. Turner to use his designation as Director of Investments when he represented himself when he to his clients or in emails, for example, the signature block said Director of Investments, correct?
Yeah, that is his title, so it's not I authorize him. This is what he is carrying.
In fact, you said, if I can ask you to look at your paragraph 21 of your witness statement, your first witness statement.
What number, please?
It's paragraph 21.
What page in the bundle?
Sorry, forgive me. I should have said that. So it is page 666.
666.
Yeah.
Yes.
Sorry, forgive me. It's your second witness statement. 737. Sorry. Forgive me for that. So paragraph 21 on page 737.
Yes, I'm here. Okay.
So it's the last sentence I would like you to point to you. You say, given Mr. Turner's level of seniority, I permitted him to use the title director, but it was understood that he was not a director. He was not a directorship. This was not a directorship role on the Tabarak's board of directors.
Sorry, you are talking about paragraph 21, right?
Yes. I'm just saying that you permitted him to use the role, the title director. That's all I'm trying to basically get to you.
He's permitted to use the title director, yes.
Yes.
So,
yeah. And you would agree that you can be a director in UAE and not be a board member, correct?
Yes, exactly.
And you can be a director and not a board member, and you can still have signing authority as a director, correct?
Yeah, you have certain authority as director, as per the employment contract. Yes.
Now, can I take you to 841?
841.
But this is Mr. Turner's employment contract with Tabarak.
Yes, I am here. 841.
Yes, 841.
41. So
And,
yes.
So the page 841 shows that Mr. Turner was employed by Tabarak, and his designated position was a senior manager, correct?
Yes.
And I just wanted to ask this, how many other senior managers were employed at Tabarak during the time when Mr. Turner was employed there?
We have 4 directors, including Mr. Turner. Each director has certain role on its department.
Would they be considered? Sorry, go ahead.
There are some directors, they need to be approved by DFSA for the role that they are playing. There are some directors, they don't need to be approved by DFSA.
But there was only one, you would agree with me, there was only one investment manager, Mr. Turner, during the time when he was employed at Tabarak, right?
Yes, of course, yes.
Could I ask you to on the same document, if you can go to page 846?
Yes, I am in 846.
This is the last page of the employment contract, correct?
Yes.
And you can see your signature, Dr. Ahmadi, and then there's Christian's signature next to you, right at the end.
Yeah, it is my signature, even though it's not very clear, but it is mine.
Sure, thank you. And there's the seal of Tabarak in between, right?
Yes, correct.
And could you inform us who at Tabarak has possession of the seal?
The seal is it is with Three people. It is with the director of human resource admin, and with director of finance, and with me.
So director of finance would be Mr. Khan, right?
Finance.
And with you. And what is the procedure for use of seal? Do you have any protocols how these three individuals should use the seal?
Okay, beside me, sometimes there are some documents needs to go out from finance department with seal. For instance, like invoices and everything. So he has the seal to seal it. It depends to the document that we are sending out.
So let's say if it's an agreement from TABARAK, an account opening agreement, who would normally seal that?
Account opening agreement, of course, as I said, they only have 3 people, they have the seal. I mean,
so any of the 3 people could seal the account opening agreement?
Could, yes, it's possible, yes. But as I said, they will only do it on my permission if it comes with account opening agreement, because account opening agreement only must be signed by me.
So account opening agreement will only be sealed once you authorize it, correct?
Yes, exactly.
Okay. Thank you, Dr. Hamdi. Now, Mr. Turner tendered his resignation to you on 19th of February 2020, correct?
Yes, that's correct.
But then upon your request, Mr. Turner stayed back and was employed with TABARAK until 30th June 2020, correct?
It's not upon my request, Mr. Salah. Mr. Turner, he submitted his resignation 19th February. And having submitted, and I'm sure you have a copy of the resignation, the reason why he resigned. And it's mentioned that he will be available, even though he resigned, he'll be available to do anything to solve this problem that he has created for TABARAK. It is mentioned on his resignation 19. And that he's not going to run away, which I trust him, of course. He will not run away. And I know for a fact he was trying to solve the issue. I was hoping. So how long it is drag on? I don't know. It was there. Then he said, so I trusted him as a normal boss and his boss. Yes.
So just for clarification, let's just look at 737. This is your second witness statement, and this is your paragraph 23 on 737.
Yes, I'm here.
Are you here?
Yes, I'm here.
So you say that after Mr. Turner resigned, I did request that Mr. Turner remain available to assist TABARAK defend the proceedings commenced by HUOBI before the Dubai court and thereafter with these proceedings. So in essence, you sought his cooperation and asked him to stay on board because of these proceedings, correct?
It was a mutual agreement between both. Because he mentioned that on his letter, it's good. I push stay and so find the solution.
So do you agree that
Mr. Mateo, I'm so sorry to interrupt. I've got feedback at my end. I didn't hear what Dr. Ahmadi just said.
Okay, I will answer what you can hear. Please.
It's feedback coming through.
Sorry, my lord, I can't hear you that well.
You can't hear me that well.
Now I can hear you. Sorry, it was coming broken.
Yeah. Well, the problem is some feedback, which is, and if we can possibly deal with it, it is obscuring what the witness is saying, this feedback.
Could Mr. Aziz put his microphone on mute, please?
Mr. Aziz? I don't know. In my room, nobody might except me and the system.
Thank you.
Well, let's see if that does it.
Should I
take him back to where in the statement you wanted to show him, and we'll take it from
so
there.
I think Ms. Stewart did not hear your answer to the question. So we went to paragraph 23 of your second witness statement at 7:37, where I read, where you stated, after Mr. Turner resigned, I did request that Mr. Turner remain available to assist Tabarak defend the proceedings commenced by HUOBI before the Dubai Court and thereafter with these proceedings. So you said, Dr. Ahmadi, that it was a mutual decision of you and Mr. Turner for Mr. Turner to stay with Tabarak till 30th of June 2020, correct?
Yes. Do you refer on number 23 now? You are referring?
Yes, yes.
737. Yes, it was first. It was initiated by Mr. Turner during his resignation, and I agreed. He said, "I will stay." I said, "Okay, you can stay, and fine until you sort you sort out this," because he's volunteered that he will not go anywhere without solving this problem. So it was a mutual agreement.
And you confirmed that Mr. Turner remained on Tabarak's work visa in Dubai till 30th of June 2020.
Actually, it was his request.
But the question I'm posing to you is that Mr. Turner remained on Tabarak's work visa till 30th of June 2020, correct?
Yeah, he remained. Yes, he remained.
Dr. Ahmadi, I heard your exchange with Ms. Stewart about your relationship with Mr. Al-Ali. You said that the first time you met him was on 3rd of February 2020. Isn't that right? That's what you said, right?
Yes, I did, yes.
And you said in your testimony that you had no way to contact him, and that's why basically you didn't actually ever meet him before or communicate with him before, correct?
I'm so sorry, I don't think he gave that evidence. I don't think he ever said no way of contact.
I can read that. I can read that back if it helps.
No problem. You mean for 3rd of February?
Yeah, I can read that back, Ms. Ahmed.
Page 8. I never met Mr. Alawi, even don't have his number.
Page 88?
Page 8, line 5.
So it's page 8 of the transcript, line 5. I've never met Mr. Al-Ali. I don't even have his contact details. Neither he had my contact details.
Yeah, that is before 3rd of February. Yes, definitely, yes.
Is that all right, Ms. Ahmed?
Yes, but he clarified that was before the 3rd of February.
But that's what I asked, precisely.
Yes.
You know, okay. So, but you would agree, Dr. Ahmadi, that you did receive emails in which Mr. Al-Ali was copied, so you had access to his email at that time, correct?
Yeah, but on that time, it was only a matter of negotiation between him and one of my members of my staff. There was no reason for me to interfere on anything at this moment.
No, my simple question is that you could have emailed him if you wanted to, correct?
For what? I don't have a reason to email him.
For example, the reason could have been that I believe you're talking about cryptocurrency and Tabarak does not, does not deal in cryptocurrency or digital assets, for example, right?
No reason for me to send an email because at this moment there's on negotiation going on with one member of my staff.
And did you and you say that you said in your testimony that on 16th of December, after Mr. Turner had his meeting with Mr. Al-Ali, you did not meet. Perhaps you don't remember, but you don't remember meeting even for a brief moment Mr. Al-Ali at your offices, correct?
I don't remember. Perhaps really I don't remember. But most probably I don't remember meeting him.
In terms of your if I take you back to 9/4/50, these are your WhatsApp messages with Mr. Al-Ali.
Yes, I had a brief WhatsApp message with him, with Mr.
Yeah. So were these the first time you ever engaged? I'll wait for you to have them. Sorry.
Yeah, I have it. No problem.
So were these the first time you engaged with him or WhatsApp, or did you engage in WhatsApp before this as well?
No, this is the first time. The first time, as I mentioned earlier to the council of Clement, we only exchanged telephone numbers during that day on 3rd of February. That's it.
And when Mr. Al-Ali says that he has met you before and he had your phone number before 3rd of February 2020, what would you say to that?
I said it's not true. I never had his number. He never had my number. I don't know where this statement coming from, but anyway, I answered this, I think, earlier.
I just wanted to double check based on your recollection again. Now, can I ask you a few questions about this internal investigation that you conducted at TABARAK after the incidents that took place on 3rd February 2020? Who conducted the internal investigation?
It's not the way you take it in internal investigation. We sat, me and my team, myself and HR and the compliance. We discussed about the matter. We said what's happened and we know the story, and I explained that. Just for everybody to know the real picture of what happened, because some of the members of the staff, they didn't know what happened in the evening after the office hours. So I came in the evening, so we discussed about it, see what everything went wrong and everything.
And you mentioned that a report was prepared just for your internal purposes to understand what had happened and what was Christian's role, and was he in any way responsible for anything that happened on 3rd of February, correct?
Yes, this is true. Only between us. It's like some one-page report.
So just an internal, these were your points of discussion, and you must have, if I could finish, Dr. Ahmadi, please, you must have reviewed all the documentation concerning this transaction, whatever you could find in that time. And is that what happened, Dr. Ahmadi? Did you review documents as well?
We only discussed about the incident of 3rd of February. Nothing before that, nothing after that. That's all what we discussed. What happened and what happened, how happened. That's it. It was very brief.
What was the date of this your internal review, if I can call it, or an investigation, as you called it?
I don't really remember. It's definitely it's after the incident.
And had Christian been, Mr. Turner been released by this time when you conducted this review?
I can't remember, to be honest. I don't remember.
And your conclusion was, after conducting this investigation amongst yourselves, that Christian did nothing wrong on 3rd of February 2020, correct?
It's not he did nothing wrong. We come to a conclusion that Christian Turner is not behind disappearing the coins.
He had no response. Sorry, Dr. Ahmadi, I spoke over you. Please.
Can I finish, please?
Yes, of course. Sorry, I apologize.
We came to a conclusion, which is the proof, that Christian Turner is not the reason behind disappearing the 300 coins. Shall I tell you what also we come to conclusion? That the conclusion is we think that HUOBI and buyer and seller are both of them responsible. HUOBI was there being expert in crypto trading. Everything happened in front of their eyes. The opening of the well, whatever it is, and everything happened. So Christian Turner was only there. Maybe there was some shortfall of Christian Turner, but it doesn't mean that he is responsible of the disappearance of the coins.
Thank you, Dr. Ahmadi. Can I ask you now about your understanding of digital assets and cryptocurrency? At what point did you know that HUOBI was a cryptocurrency company that deals in cryptocurrency?
This is during that email exchange between Christian and HUOBI, when I saw the structure, one of the structures. This is where I came and I spoke to Christian about it. Why? Because he explained to me, yes, I already explained to the council about it. And
so you were,
Christian knows, can I finish, please? Christian
sorry, yes.
knows very well, and I'm sure he knows until now, that TABARAK does not deal with cryptocurrency transactions.
You were well aware of cryptocurrency and digital currency companies. You could identify them, Dr. Ahmadi, correct?
No, actually not. Absolutely not. My knowledge on the cryptocurrency is very limited, to be honest with you. Very limited. I don't even. Okay, I hear about Bitcoin and I don't know other companies. I don't know how they work. I don't know which is the biggest company who deals with cryptocurrency. Only later on I came to know about HUOBI.
Okay, but you were aware of Nicarius, coin, and you were trying to build a gold-backed, cryptocurrency coin and market for that, correct?
Yeah, but Necros it's not been created yet. It was just an idea. It was just a proposal.
By what I'm trying to put to you is that because of that experience, you must have gotten some exposure to this industry. You must have learned new terms, and you must have understood how this industry works and how it functions, and different stages of this industry, and so on and so forth. Correct?
The only thing I know why the regulators around the world are not regulating the cryptocurrency business, because none of them are backed by any solid assets. That's why. That's what my understanding is.
But Dr. Ahmadi, my question is that you would have gotten some understanding of digital assets and cryptocurrencies because of your association with this coin backed by physical gold asset, correct?
Yeah, see, there is no coin backed by physical asset at this moment. Only we were discussing about it, if you mean about Necros and gold reserve sukuk. But as I mentioned, I have limited experience and information about cryptocurrency and how they work. That's it. My limitation of experience, knowledge of cryptocurrency, like any other, not even banker, any other individual.
Dr. Ahmadi, for example, one can understand different financial products, but one doesn't need to be a trader to know how to basically trade them.
I'm very well aware about financial instruments, funds, mutual funds, MTNs, but I know this how they work. But I don't know how the cryptocurrency works. That's like any other normal person knows about cryptocurrency.
But in 2018, you entertained two proposals, which involving cryptocurrency backed products, correct?
It's not I entertained two proposals. There was only one. Piconio is different. I know what you mean. You mean Piconio. Piconio has nothing to do with proposal. Piconio was going to come and buy shares and establish a gold trading desk. Piconio, yes, it was only initial discussion. How this coin can come with backed by gold reserve sukuk, which we have it in our hand that days, approved by DMCC and registered in the IFC. So we were just thinking on how we can combine them together, can do something that we presented to our regulator. Do you agree on this or you don't agree with this? But eventually, none of this, both proposal that went through for a long time. It's all because of the wrongdoing of other parties. We stopped it.
When you received the letter of intent from Piconio, you must have had the curiosity to learn a little bit about Pecunio, correct?
Yeah, because of course they talked. Of course, this has been explained to me by Mr. Tanner exactly that they are a blockchain company. And the blockchain, as far as I know, blockchain from that time, blockchain is type of technology company. They provide systems for cryptocurrencies or any other digital assets. Because at the end of the day, there is no company can be established in UAE dealing purely in the cryptocurrency, or even they call it so on ABC cryptocurrency.
But cryptocurrency, you'd agree, Dr. Ahmadi, is a digital asset.
I that term is digital asset. For my understanding, digital assets different perspective, which I explained to the other council earlier. Digital assets, I never know that cryptocurrency. I still don't know. Don't think that cryptocurrency is digital.
So when you were considering and reviewing those proposals of Pecunio gold coin, which will also be physically backed by gold, did you not basically think that this was a digital asset at that point?
Mr. Salah, you're still mixing up between Pecunio and Pecunio was not. They did not come to us as a cryptocurrency company. They came to us to buy shares of TABARAK and establish a gold trading desk, physical gold trading desk or paper gold trading desk. That's a different story.
So your testimony is that vis-a-vis Pecunio, the deal didn't materialize, and you just after the letter of intent, you just moved on, correct?
No, we did not move on. Actually, we did not. There was no agreement signed between us because then it did not materialize. They couldn't purchase the shares of TABARAK first of all as agreed, and they didn't have the money to purchase, so we closed it.
Mr. Matu, we're on the hour. Presumably you have more than sort of 5 minutes of re-examination, I'm sorry, of cross-examination to undertake. And we'll adjourn. I'll just remind the witness, I'm sure he recalls, that please don't talk about the case to anybody as we stand adjourned, and we shall resume tomorrow at 8:30, will we?
I beg your pardon. It was my understanding, and I'll stand corrected if I'm wrong. I don't think tomorrow is an effective day. I thought the next time we were sitting was the 5th of December.
No, the 5th is a DA's known, isn't it?
It's the 6th of December. My apologies. So tomorrow we're not sitting.
So tomorrow we're not sitting.
Yes, okay. And then the days are 6th, the 9th, and the 12th. As I understand.
Yes, there were difficulties with the Wednesday and Thursday. I'm sorry. Yeah. Okay. So we resume on the 6th.
That's correct. Yes.
And is that the day when the expert can do 2 hours only from Vancouver?
No, that's the 9th of December. So Mr. Sim.
Right, I'll make a note of that right away.
At 12 o'clock, Dubai.
Okay. So we're going to resume. We resume on the 6th.
Yes.
Right. Okay. Thank you. And that'll be at our usual time at 8:30 London time, 12:30 Dubai time. Thank you all very much.
Thank you very much.
Thank you.
Goodbye.
Goodbye.
Bye.